Work was good. This shit right now, not okay. I am very frustrated. I just want to be in the court. Can I leave the car? Whoopsie.
And cherry blossom milkshakes. Hello, Sunny.
Hey, door.
You want into this one?
Yes, please.
There you go.
Thank you. I will not go into the courtroom and argue a case that there is no evidence. No, not really. not any evidence. I have most piece of meat tonight. But see, I am sure it will be the night. I have no idea. Probably nothing. Let's refresh the booking. What's up? I'm just chilling. I'm getting ready to walk into the lion's den. I am really wrong. Oh shit, I locked that door. Oh well, I got to go.
Or the other one is every time I'm in here, my head hurts like 10,000 times more than.
Got a good sense
in
of
a
direction.
general direction. He doesn't know where he's going.
Going to trust that none of you guys have weapons. All right,
I
let's
do.
go. Please put them away.
No, that's a joke. My weapons
okay.
are my words.
Oh, figured. Hello, Sonny. After you.
Thank you.
Sonny!
Oh Lord.
Willow, I'm sorry I tackled you.
Me too. Actually, you know what?
It's okay. Big hug.
But, you know. Toby. Hi, Killian.
What about Kobe?
You know what? I'm gonna come sit up.
All right. So is everybody ready to start, or you guys need a couple of minutes?
I'm ready to get started, Judge.
Yes, Your Honor.
Okay, perfect. So this is going to be in the matter of 2023 CM304. This is going to be a pre-trial conference on this matter. I will not have security. No one is allowed in or out of the courtroom until the end of this proceeding, just due to the sense that I don't have security. So I guess let's begin. If the state can just state their name for the record, please.
It is being Sonny the Governor.
And for the defense, please.
Hey, I'm Oliver Hall.
And if the defendant can just state their name for the record as well.
My client is having a
completely okay.
Yeah, she's fine. She's Adrian Jackshill.
Oh, okay, perfect. Do you wanna give it a couple of minutes, or are you fine with proceeding?
Give me a moment. Let me see.
Sure.
Yeah, if we could just have a few moments. She just dropped some papers. She's grabbing them under the desk there, as you can see.
Sure thing, sure thing.
Hey, that's a lie. I have many.
You'd never seen him in his birthday suit.
I have many other suits. Beside this one, this suit is clean. Yep.
Yeah, why'd you have that weird inflection on that?
It is.
Clean?
Well, listen. All I can say is I'm here and now in this beautiful courtroom, and I'm ready to argue. Let me tell you that.
With the ugly carpeting.
It's unique.
I like the maple leaves, but the rest of it. No, only cool magistrates who never show up to work get pictures. Yeah. Like Nick Davies, there's two of them up here. Sure does. He's the guy with the yellow glasses. Anthony Coronado has two of them, though I occasionally see him. He only shows up when he has a case. He doesn't show up any other time. She texted me 2 days ago to tell me she was engaged. I'm like, congratulations, me too, I guess. Mhm.
No, I've never been engaged.
Well, yes, I have. To the
That's a
law.
lie, Oliver. You're engaged to the law.
I
That-
just
yeah.
said that over
You know what,
here.
you know what? I listen. I think that's good. I'm engaged to the law.
Yeah.
This
Well, you're
is
more
so
married to the law than anything else.
That's a good point. Love the law. I kiss her every night.
Okay. Is your client ready,
Yeah.
Mr. Hall?
Yes, we're ready to get started here.
Okay. So considering the state requested this to be a pre-trial conference, I'll let the state lead.
Thank you, Your Honor. Your Honor, at this time, the state is wishing to be having the charge dismissed without prejudice.
You're wishing to dismiss all charges without prejudice?
That is correct, Your Honor.
Okay. Is there a reasoning behind that?
The reasoning behind this is the investigation is still ongoing. There are warrants submitted, subpoenas approved, evidence still not being returned. And the investigation not complete, charges were being pressed prematurely by the police.
If I may, Judge, I don't know if there was more there from the state, but we do have arguments on this if you'd allow it.
Sure. Yeah, go ahead.
Thank you, Judge. Now, the reason for the dismissal without prejudice, now we'd argue that the court should order the dismissal with prejudice. We certainly respect the state's lawful ability to drop charges and dismiss charges, and for the court to give leniency when dismissing charges when the state is dropping them of their own volition. But in this case, if the state's intended reason to dismiss these charges is simply that they didn't do their homework, that the cops didn't do their jobs correctly, and they didn't properly investigate this case prior to it being brought to trial, but that's insufficient cause for the case to be dismissed without prejudice. And instead, the court should dismiss this case with prejudice. Either this case should be heard as it's scheduled, or again, it should be dismissed with prejudice. Again, if the sole reasoning is for an improper investigation, the state had its time to properly investigate this matter.
I
Instead,
had
they
5
didn't.
fucking
They
days.
waited until the last minute, and it sounds like they're coming up with evidence out of the blue, or trying to come up with evidence out of the blue to, again, continue with these baseless charges. If the state had
We
some
do not know if the charges
actual,
are baseless.
reasoning to drop the charges other than for just to investigate further, perhaps we could, not contest this. But if the sole reasoning is to investigate, then again, they should have done their job at the start. I mean, this wasn't a case where the defendant was arrested on like a bank robbery on the scene, and the cops had to arrest her there, and then after witnessing the bank robbery, and then they didn't have the opportunity to really fully investigate because the case was scheduled so soon after the fact. This is a long case. This all started back in on the 23rd of September. The cops didn't arrest my client on any scene. They didn't have any reason to swiftly arrest her. Instead, they investigated. They brought the charges hastily, but that's on them. If they brought them hastily and they didn't fully investigate, that's on them. That's on the state for rushing an arrest when this case was being investigated. It wasn't a case that was going to be swiftly, brought to trial for more reasonable reasons. Instead, they had the opportunity to investigate, but simply chose not to. So if the court is going to order a dismissal, again, we certainly don't contest that this case should be dismissed, but we'd ask it to be dismissed with prejudice rather
Of course
than
you
without.
don't.
Okay. Anything else from the state?
Yes, Your Honor. I'm doing this job in the pursuit of justice, to be seeking the truth. I cannot, in good conscience, be pursued charges without the truth. Is Lady Jax guilty of these charges? I don't know. It is not possible to know at this time. Is she innocent of the charges? We do not know.
Okay, so so here's the thing: the case has been on the docket for 17 days so far, and I imagine law enforcement did their diligence prior to the 30th, which is when the indictment was filed on the docket.
You can imagine
So-
that all you want.
We're 17 days in. We are 2 days away from trial. How has I've stated on numerous occasions on this docket that evidence needs to be collected and processed and submitted to the docket as well as the subpoenas in a timely manner. None of this has been brought up until this point when we're 2 days away from trial. I'm not fully understanding.
Your Honor, I become first chair on the 11th.
Mm-hmm.
I had a matter of days to review all of the evidence, all of the information, to be making this determined. And in the court date scheduled 2 days after the scheduler link, there is simply not even enough time to be
I
determined.
disagree with you, Miss Kavanaugh, Miss Day Kavanaugh. Sorry, you've been assigned to the case since the 30th. So saying that you were assigned for, you should have been up to date with the case from the moment you're assigned to a case. You need to be paying attention to it, because God forbid we go to trial and Ethan Casey dies on the spot. You need to be able to take over right then and there. So you taking over as quote unquote first chair has no bearing on this. You've been assigned to the case since the day it was since the indictment was filed. Whether or not you paid attention to the case until you were given first share, that's on you. That's not on myself.
Okay, yes, it
this
is
court,
on
nor
me.
the defense.
Then I will motion for the continuance. There is not enough time to determine whether or not witnesses are able to attend, to get the affidavits, and to get the necessary depositions.
Well, Judge, of course, we contest the motion for continuance. I think we're still waiting on the court's ruling as to the dismissal. Again, we'd assert that just the state not having done its due diligence in fully
I did my
investigating
fucking
this
due
matter
diligence. That is
prior
all
to
I
it being
fucking
brought to
did for the
trial,
past 2 fucking weeks.
is a sufficient basis for the court to order a dismissal with prejudice. But with that, of course, out of the way, we ask that the court first rule on that motion.
This is
And
not
then as far as
justice.
the
I will
continuance
fucking
goes,
resign after
I mean, the
this.
state had the opportunity to, again, inform their witnesses. The court even put out a scheduling notice to all witnesses to provide their availability in the scheduler. All witnesses, at least to my knowledge, have done so. That this case was, sorry, I keep getting called, Judge. This case was scheduled with the availability of all witnesses in mind. Now, if the state had any confusion as to whether or not their witnesses were going to attend, they certainly should have made that known previously.
How
This
would I
certainly
know
sounds-
if they were going to attend if I didn't know the fucking court date before?
I'm sorry,
Ms.
Judge.
Kavanaugh, I don't know what is going on, but I'm not going to allow the profanity to continue. I mean, you're in a courtroom. In
Hold
the middle
me
of
in
an active
fucking contempt.
proceeding. Do you need a moment? I can put us into a recess, but I can't allow the outbursts like that to continue. It's disrespectful to the court.
No, Your Honor, I am fine.
Thank you, Judge. That was completely unprofessional. But as I was saying, again, the witnesses were called, and then the trial was scheduled. Again, this seems to be just a sneaky maneuver the state's trying to pull to now weasel their way out into more time to prepare for trial. When they, again, should have investigated this case, made sure that they were prepared for trial prior to even arresting Ms. Jackson. Instead, they failed to do so. So instead of trying they're just trying to weasel their way into more time to investigate, Judge, which we don't believe is a proper reason for continuance to be granted. All witnesses have and should have provided their availability on the scheduler. They've been subpoenaed to attend. So if they don't show up to trial and they haven't made their unavailability known to the parties in the court, and that's on them if they're, of course, the court issues a bench warrant, which certainly they should. You should, Judge. But again, this isn't sufficient basis. No one's made the court aware, any party aware that they're not going to attend trial. So it's really a non-issue.
Attorney Dave Kavanaugh. So here's my thing. Okay, so you stated that warrants had not been completed. I know which warrants you're speaking of, and they are being reviewed. Number one, in that aspect. Okay. In regards to depositions, we have 3 clerks here right now who I'm sure can make themselves available at some point tomorrow to complete those depositions, should they be requested, which they have yet to be requested on the docket, I believe, unless that was part of that long evidence request, which I have not reviewed yet because the defense has not made their judgment call on that. So in regards to the warrants, I'm sure those will be reviewed and either approved or denied within the next 24 hours. Regarding the depositions, I'm sure they can be completed tomorrow, given the availability by the individuals who need to complete those, should it not be objected to. I personally, so given the fact that Speedy Trial Act does not appear, it has been reenacted, but it does not apply to this trial, does not mean I want to string out this trial for another month. Nor do I really want us all to have to come back into this courtroom and have this case be reheard, because as it stands, 90% of the judiciary is conflicted out of this case, and I will have to remain probably being the one who presides over it again should it be refiled if I allow a dismissal with prejudice. So let's come up with a conclusion in some form of way right now to see if there is a possibility that we can keep the trial scheduled for Thursday.
It is
and
not possible.
Get everything that you need to get done on the state side of things accomplished in a timely manner prior to trial. If all parties are okay with this, I'm happy to allow the submission of evidence and discovery up until 4 hours prior to trial, but it has to be agreed upon by the parties. Otherwise, I can't do it. So I mean, we can let's start with that. Are we fine with that, or are we going to go by what my latest ruling is with the discovery period?
No, Judge. The state would prefer that the court keep to its previous orders with respect to discovery. I'm not entirely sure what this
I am
evidence
the
the state's
state.
trying to acquire is, but whatever it is, 4 hours is certainly not enough time for the defense to prepare. I have come prepared if the state is withdrawing their motion to dismiss. I've already come prepared with a motion to suppress evidence, and I believe that whatever evidence they are attempting to acquire and present based on these warrants, subpoenas, whatever they're attempting to acquire, we certainly are more than likely going to object to or motion to suppress or exclude, strike, based on its inadmissibility. And we'd prefer to have enough time to submit those motions and prepare those motions with the current discovery timetable, because that will allow the defense to examine the evidence, again, determine if it's inadmissible, and then we can preferably just hear out those motions prior to trial on the day.
Give me one moment. I'm looking at the schedule. I'm pretty sure that Thursday is the only day, but I will re-review and try and make accommodations, but I'm not too sure. Give me one moment. Yeah, any other day other than Thursday has a minimum of 8 people that are unable to attend, rather than the Thursday, which has 1, 2, 3, 4 people unable to attend.
Those
And
4 people include key witness and the victim.
The key witness is the victim doesn't appear to have even filled it out. Have you spoken to the victim?
Yes, Your Honor.
And have they given you any availability?
Let me check. Oh my god, it is so hard to fucking find shit in here. He did not give availability. He said he cannot attend the court. Very busy that day.
Okay, and who's your key witness?
Well, Mr. Domingo and the victim, Mr. Rochester.
Mr. Domingo, I marked his availability as present for October 19th at 9 o'clock.
He sent the email. He said this is late for him.
So, hold on. Let me do some math really quickly. Okay, so my scheduler spans from the date of indictment 35 days, which would end on November 4th. Okay. So at that point, the defendant would be on bail for 35 days. However, it would be extended past that 35-day mark because, as I stated, nobody's availability matches up past Thursday. So that means, should you refile, this case is going to go ongoing out into the month of November and potentially December. So are neither party able to provide affidavits? Hold on, let me look at one more thing. It does. I mean, I can push it back an hour, which he has. So at 8, from 8 to 9, Mr. Domingo has marked and confirmed availability. However, from 9 to 10, it's a maybe. So we can start. I mean, I expect this trial to go for more than an hour, well over an hour. So we
Yes.
can push back the trial an hour and start it at 8. And for the witnesses that could not have penned at 8, it can be held off later on in the evening to 9 o'clock, where they show their availability as present. Would that be better, Ms. Day Kavanaugh?
I did email him to see if he will be available the hour before.
And then, as for the depositions, can you post those to the docket now so that I can speak with my clerks and see if I can schedule something with them?
I am still working to see what witnesses are available. It takes time for people to respond.
Okay, give me 1 second.
Where the fuck is this other email chain? I don't think I have it.
Okay. Yeah, none of my clerks are available until 5 p.m. Eastern to do the depositions, and then they would need to be transcribed and posted to the docket. So
We are not interested in
Your
justice.
Honor, with consideration of this matter, sometimes witnesses are simply unavailable, and there's nothing that the parties can do to satisfy their availability. That doesn't mean that the court should bend over backwards for them or the state. We believe that the court should keep to its timetable. And these witnesses, it's unfortunate they're unavailable, and perhaps we can't get depositions from them. But the original timetable should be kept to.
Okay, so let's start from the beginning. Is the motion to dismiss still on the table from the state?
Not with prejudice, Your Honor.
But are you still requesting without prejudice?
Yes, Your Honor.
Okay. And Mr. Hall, you're still requesting either the case be heard or dismissal without or with prejudice. Sorry, or which is it? What are you looking to do?
He
That's
wants
right,
to
Judge.
dismiss with
Preferably,
prejudice.
we'd like for this case to be dismissed with prejudice. We'd like to join on state's motion in part, but we request that the dismissal be issued with prejudice. We're happy to, if the court wants to reserve ruling on that, because we have other motions if this case is to be that if it's not to be dismissed with prejudice, we do have other motions to suppress and other matters to settle, or we'd like to be settled before the court issues its ruling. But again, we'd like for the dismissal to be with prejudice, because the state's motive for requesting the dismissal with prejudice, again, is simply to delay and to request more time to investigate, which they should have already done. And we believe that that sort of malfeasance is cause in and of itself to warrant a dismissal with prejudice. The defendant has already suffered enough time with this matter. Again, the state didn't do their due diligence in full investigating before bringing it to trial. That's
It is
on them,
not
and
my
we
job
believe
to
that the court
investigate.
should
I did
issue a
spend time
dismissal that
to
reflects that.
investigate.
Okay, give me. We're gonna go into a 10-minute recess while I debate
Your
the
Honor,
dismissal. Yeah.
if I may, the
Mhm.
only interest of the state is the truth and the pursuit of justice.
I understand that, and I'll take that into consideration. But also, elongating this trial beyond what will be 32 days is not really in the interest of the defendant either.
It is not in the interest of the
As it
victim.
stands, this is kind of a high-profile case. So I want to try and get this resolved as quickly as I possibly can for all of those involved, from the defendant to the state, to the clerks, to the security, as well as the witnesses and the general public that are waiting for the outcome of this case. And of course, obviously, as well as the victim. So we're going to go into a 10-minute recess. I'm going
Should
to
not the outcome be
deliberate
rooted in
on
truth?
whether or not I'll dismiss without prejudice, or dismiss at all, or if we'll be continuing the case. We'll be back in 10.
Thank you, Judge.
Are you trying to exit?
It's good.
Wow. Yeah, like I only show up 9 again, but to be fair, that's more than Oliver.
Hey, listen here, buddy. I control your paycheck.
Right?
Why are
Dude.
you up here, by the way? You work for the firm?
I wasn't. I didn't know, nobody signed me onto the case. I didn't ask for it.
Listen, firm unity. Somebody needs to teach you that. Always, firm always
Okay.
works together.
Okay. Right. I feel. I feel like I can't go up there in these pants. So do you want to swap pants real quick, Oliver? If you sit down and then I just wear the pants and stand up.
What the hell are you saying?
I'm just trying to make myself sound like an idiot so I don't have to stand behind the desk right now. That's what I'm doing.
Nobody wants to work anymore. It is a judicial cabal. I'm gonna run for state rep, get elected, and I was gonna do what I was gonna do before and write a law, the totally not a conflict act. So then I can be a lawyer. Well, listen, actually, funny enough, I wrote that law. Totally not, and I was gonna post it, and then I closed out of it, and then it deleted. So it never happened. Yeah, I didn't feel like rewriting it. None of it saved, so I gave up. That would have been an interesting law. Oh, you know what? I don't know. See, they're trying to make. I saw a new psych hold law that's just mine, but worse. I don't understand why. Listen, yeah, I can see that aspect. I think it certainly was long, but here's the thing. Okay, most of it was copy pasta because these other psych holds, the only parts that were like changed really were just like the what am I trying to say? The procedure for it. Yeah, because the first one that was it, and then the second ones were like, okay, the psychiatrist you can, issue a second hold, and after that has to go to a judge. Then the rest of it, I don't know why they're changing all that. That I think that was all pretty good and necessary, like the sanity stuff. I get her responder. I forgot. Yeah, I told her it's to be all lawyers. All lawyers get to vote. Actually, I think all the people, everyone should vote. At least it looks. That's true. I think. I personally. Go ahead. I would always send a whole bunch of emails to inactive lawyers to get them to vote for me. I don't know if that worked, but I did it. Yeah, I did. Hey, listen. I mean, you got to do what you got to do to get elected. Listen, I think that the people that are affected most by the Chief Justice, which is all the lawyers, should be able to vote. Well, I think it's at least a good change. Again, I think all the people should vote. Everyone should have their voices heard. If you're alluding to the communist flag, I want to make quite clear to you, Dana, I don't know who you are. Whatever. Whatever. Listen, I'm not a communist, okay? Well, I single-handedly destroyed the San Andreas Communist Party. Thank you very much. What? Listen, all I can say is I destroyed them, and I used to be a I'll admit I used to be a communist, but Christopher Stevens. Right, exactly. Christopher Stevens, he showed me the right path. Through his harsh, unforgiving ways, he showed me the truth of being an American, and I love America. I'm no communist. Those flags in there, my office was vandalized by Cyrus Hunt and Donald O'Hagan.
Oh yeah.
Wait, hold on. Sorry, I'm not.
No, get out of here, I say, you communist.
Nope. Where's the habit? Give me one moment. Okay. So I have thought about everything that has been discussed today. I have also consulted Associate Justice Alfie Young, as well as Associate Justice Gerhard von Manteuffel in regards to what has been argued today. And while at the end of the day, it is my own decision, in regards to the ruling of the dismissal, I did feel more comfortable bouncing ideas off my colleagues. And it seems that we kind of all are in agreement with the same consensus. That being that I will not be granting any dismissals for this case whatsoever. So therefore, the state's dismissal without prejudice is hereby denied, and the counteroffer by the defense for dismissal with prejudice is also hereby denied. I will be point blank, and I'm going to make it quite clear the reasonings behind this. At the end of the day, like I stated, the indictment was filed on the 30th.
And while I understand that the state had a chair adjustment once you were assigned to a case, you need to pay attention to it from start to finish. And if you're not going to pay attention to a case, you shouldn't be assigned in the first place to the case. I also want to make it clear that the issue is also on the side of law enforcement. Law enforcement should not have made the indictment or filed the charges and made movement to arrest the defendant in this matter if they weren't ready. So the blame is not all on that of the state, but also that of law enforcement. So we will be proceeding to trial on Thursday, and I would grant a continuance, foregoing the fact that the defense did go ahead and object to said continuance. However, as stated, I have provided availability on the scheduler all the way out to November 4th, at which point no one is available. So what I will be doing to accommodate the state with their key witness, as I stated, the witness did go ahead and provide availability for an hour earlier. So I will be amending the time in which trial starts at 8 p.m. instead of 9 p.m. I will allow those that are unavailable at 8 o'clock to come at 9 o'clock as they were originally subpoenaed to come to. But for this individual key witness of the state, I will allow an hour earlier trial start date to accommodate that witness. Any notations before we move on to additional motions?
Nothing from the defense, Judge. We thank you for your ruling.
Until which time? Give me one moment.
Your Honor, if I may.
Just give me 1 second. 1 second.
Yes, Judge.
Attorney Day Kavanaugh, are you the one that submitted the subpoena request to Medical? Or was it? Okay, 1 second. Who did you submit it to? Okay.
Shit, sorry.
Okay, so my clerk is calling the hospital right now to get that process and squared away for you now, because typically Medical does not like to comply with orders. So, was there anything else you had to say before I let Mr. Hall speak?
Yes, we are still waiting from the 7th of October for the information from the warrant approved to be submitted.
I'm sorry, just before going any further, can the state clarify as to what this warrant is for, what documents you're attempting to obtain?
Yes, it is the approved search warrant for the GPS location and phone records of Lady Adrienne Jacks on the night of the incident between the hours of 7 and 8 p.m.
Well, in that case, Judge, I suppose we'll handle this in two parts. First, we'd like to, I suppose, file a motion to quash that warrant for privilege. And then barring that, we can issue a response if you'd like as to the extension of discovery.
So there's
That'll
two
sort of follow from
warrants.
this.
There's two warrants that are being requested for this case.
There is
Correct?
2 currently that are pending judicial review and 1 that was approved.
Okay, so let me read these. I don't see any regarding this GPS location is for not that of the defendant.
I can share with you the signed warrant.
Is it by Logan Rhodes on Wednesday at 8:33 p.m.?
No, it is before that.
9:49 a.m. on Wednesday?
No,
Those are the only two that are pending.
it is not pending. It was an
Oh.
approved warrant, but we are pending the information from the warrant that was approved.
Is it 4:42?
Yes. It should have been 6 p.m.
Okay, and what are you're claiming privilege in what regard?
I'm sorry, was that directed to me, Judge?
Yes, sorry, Mr. Hall.
Say that one more time.
You're claiming privilege in regarding to suppressing this warrant under what grounds?
Yeah, that's correct, Judge. Now, the records that are being sought come from, of course, Mrs. Jack's phone records. Now, I don't think it's a surprising fact for the court or anyone else that Miss Jax is an attorney and that her records, of course, have almost exclusively contain privileged information. Information that's subject to attorney-client privilege, and she, of course, would exercise that privilege in barring the use of any of those records at trial.
I don't know that this would be considered privilege, as it's not asking for the contents of conversations, nor phone logs regarding phone calls or text messages included on this warrant.
I'm sorry, Judge. It sounded like the state said they were requesting those records. The phone records,
so
call records.
The warrant which has been approved, which I'm reluctant to say, the people in the gallery are going to have to leave the court for me to continue this conversation. This is a sealed warrant.
Come on, guys.
Oh, shucks.
Okay, so this warrant is subject to GPS and cell tower triangulation data. It does not contain anything about text messages, phone calls, Twitter postings, Y postings, anything on social media, nothing of that nature. It's simply just GPS and cell tower triangulation data. And like I said, I don't see that being privileged unless you can advise me otherwise.
Yeah, I apologize, Judge. I believe that at some point in the state's arguments, they did bring up a request for the phone records and call records and other privileged information. As far as the request for this particular information, we are not going to assert any sort of privilege.
Okay. So
we do have arguments as to a continuance, so if we may.
Continuance, and we're not continuing the case. The case will be heard on Thursday.
Thank you. As to the discovery is what I meant.
Oh, sorry. Just one moment. I just want to finish up on these warrants with the state. So Attorney De Kavanaugh, can I just call you Attorney Kavanaugh just to make this quicker? Do you mind?
Yes, Your Honor, you can.
Okay. So Attorney Kavanaugh, so I just spoke with Associate Justice Young. So personally, I can obviously review these warrants myself, but I don't feel that is in good faith. So I did speak to Associate Justice Young, and he'll be reviewing them tonight or early tomorrow morning. At which point I recommend putting an urgent pressure on the individuals. So it would be the cell phone company. In which I can also provide a legal demand that you can provide them with. and I can post that to the docket concluding this conference to assist with that. So we'll get these warrants sorted out for you. Was there anything else you had to add before I move to hear Attorney Hollow?
Yes, Your Honor, if I may. Again, we have been waiting for this information, pressuring the company, asking many times since the 7th of October when it was approved. Also, I am not being available before 5 p.m. tomorrow after to this evening. I unfortunately have another job that I must be working and do not get to be to the state until 5:30.
With regard to what? I'm sorry. The trial would be
With regard to the discovery
Oh, okay.
and the acquisition of any affidavits or depositions.
One moment. I'll get to you in 1 second, Mr. Hall. I'm just looking at something. Where the One moment. So, what about Attorney Hunter or Attorney Porter?
Attorney Porter has resigned. Miss Hunter, I am not knowing. I have not seen her.
Okay. Okay. Attorney Hall, go ahead.
All right, thank you, Judge. As far as the discovery, I certainly understand state's issues with attempting,
Of course you
best as they
understand.
may, to obtain the records. We're willing to compromise and allow or ask the court to extend discovery only up until 12 hours before trial, exclusively for the approved warrant as to the cellular location. I mean, the rest of these warrants, we believe there would be, for us to have the proper opportunity to raise objections and motions on them, which we certainly will. We believe we need at least 24 hours to review and, of course, formulate our arguments prior to trial. As far as the time it's taken, again, these weren't filed far prior to the arrest of the defendant and filing the indictment. There's been plenty of time for these to already have been filed. We'd also ask for the warrant and all that to be disclosed, at least the one that's been approved, so we can review it. But as far as the other warrants, there is sufficient time to both acquire the documents, for us to review them, and then to file motions on them. So we'd ask that exclusively discovery be altered only for the approved warrant as to the cellular triangulation data and all that, specifically 12 hours before trial to be submitted.
Okay.
Your Honor,
Yeah, go ahead.
if I may, those warrants were issued nearly a week ago. It is not the fault of the state that they have not been reviewed.
I understand. Yeah, I'm gonna work with the cell phone companies, concluding this trial, to try and get those moved along. Okay. And as I said, my clerks are currently working to get medical to fulfill their end of the subpoena as well. So what I'm gonna do is I'm gonna revert part of my ruling on line 35 of the docket. So what I'm going to do is I'm going to go back to my initial statement where where discovery will close at 8:00 p.m. Eastern Standard Time tomorrow. However, the submission of the warrants will be posted as approved and by the defense 12 hours prior to trial, which I don't know off the top of my head. I will do the math. Everything will be posted to the docket immediately, concluding this pre-trial conference. I've been taking notes. So like I said, the state will be able to submit the affidavits by 8 p.m. tomorrow, and they'll be fine as long as there are no objections by the defense. As for the warrants and the information contained in those warrants, they have until 12 hours prior to trial, which I don't know the time off the top of my head, and I will provide that immediately after the commencement of trial. Does that make sense for all?
Yes, thank you, Judge. Again, we'd ask that the state hand over the warrant that's already been approved, and then, of course, hand over the ones that subsequently get approved. But we certainly appreciate your ruling, Judge.
Okay. I don't even. Attorney Kavanaugh, do you have access to that warrant? I know it's sealed.
I only have access to the signed warrant,
Okay.
not the probable cause for the warrant.
I will provide the probable cause to all. Really quickly though, before I do that, I know that the defense. There's a bunch of things we need to discuss at this. So the defense requested the remainder of this case be. Give me one moment.
Oh, sorry about that.
What was I know the defense requested the continuation of this case be sealed, and there was no objection by the state. However, I need to know the reasoning as to why we want this case to be sealed before I proceed forward.
Oh yeah, no, Judge. I want to make quite clear the request to seal that was specific to. We believe that the state has the intention to attempt to submit the phone records of Miss Jax as evidence. We'd ask that any phone records at all, if they are to be submitted, that a sealed docket be created, that the state submit those records, and then we inspect and provide any motions or argument as to the admissibility of those particular records on the sealed docket. Again, the main reason for this is we do believe that the state is either attempting to obtain, has, or will at some point attempt to submit Miss Jackson's phone records.
When would you like for me to do that?
And again, we're asserting privilege, and we don't want those records to be publicly distributed, as of course they contain highly sensitive information, and we are asserting privilege over them. So it's just specific to that sort of evidence that we're requesting a sealed docket for.
Okay, is the state going to be submitting any form of Miss Jackson's text records as evidence?
As noted in the docket, Your Honor, we are in possession of a single text message between the defendant and a third party.
Okay, so what I would like you to do is I'm going to, right now, I'm going to go ahead and move forward with releasing this probable cause affidavit to the parties. And when I do that, if you can submit whenever, as long as it's within the discovery window, if you can submit that text message under seal in that area, that would be great. Is that okay?
I don't know how to do that.
You would just submit instead of submitting the evidence to the docket, you'll submit it to the seal docket that I'm about to create.
Yes, Your Honor.
All right, give me 1 second to do that before I forget, and then we can proceed with anything else we have to go. Attorney Hall, do you want your client on this?
Yes, please, Judge. Absolutely.
No, she will not go to jail.
Okay, that has been released to everybody. Um,
Perfect. Thank you, Judge.
okay. Was there anything else from the state? Or have we kind of covered everything so far?
It is fine, Your Honor.
Okay. Give me one moment, Attorney Hall, before we move on to your motions.
Your Honor, is this sealed evidence where you would like the text message to be submitted?
Yes, please.
Your Honor.
Sorry, yes, I was speaking with the phone company. Go ahead.
Thank you. We've taken a look at the warrant. Now, again, we're going to move to quash the warrant as the warrant itself is requesting the phone records of my client. Now, we believe the language of the warrant is for all phone records and is not specific in scope to what the state is asserting it is, that being the location of the phone from the 23rd at 1900 to 20 Eastern Standard Time. We believe that the warrant that has been sworn out is for all of the phone records, and because it's overly broad and contains privileged information, we'd ask that it be quashed.
One moment. I'm just reading it. So it looks like. Oh, 1 second.
Fuck.
So it looks like off Detective Rhodes requested geolocation, and Associate Justice Joanna McGrath approved phone records as well as GPS location. So I'll allow the GPS location, but I won't allow the submission of the phone records because that was not what was originally requested. So, Attorney Kavanaugh, when this warrant has been completed and provided to you, the only thing I'm really allowing is the GPS location, is because that's what was requested in the initial warrant. I'm not sure why Associate Justice McGrath approved phone records, which were not in the initial scope.
Judge, we actually asked that a special master be appointed to review the production of any records under this warrant, and for the records that are produced to be parsed out, and only the records that are, of course, the geolocation information be provided and produced to the state and the defense. That way, so there's no worry that the state may get their hands on privileged information. And this special master, they can take care of that. And again, make sure that anything that doesn't need to be in there is axed out in case there is confusion with the services warrant.
Is there an objection from the state on that? If you need clarification, I can provide that.
Yeah, that would be great. I don't know what the master is. Is
Yeah,
it
so
like a
it's
Yoda?
No. So what a special master will do is the warrant will be served, and the data recovered from the telephone company. They will provide that to the special master directly. It will not be provided to the state. It will not be provided to law enforcement. It will be provided to the special master for which I appoint. At which point, the special master will then go forward with reviewing the data for which has been submitted, and redact information that is considered privileged. At which point, it will then be sent to you, or the state rather, for submission into evidence.
I have no problem with that, except for, Your Honor, the submission is restored by the court. Deadline will be 12 hours prior to the trial.
Yeah, I'm likely going to assign myself and Gerhard von Manteuffel as the special masters for the information.
What is a Gerhard?
Gerhard von Manteuffel is an associate justice with the Supreme Court.
Thank you, Judge.
Just let me take note of that as well.
Your Honor, what of the other warrants that are still pending review?
One moment. Those will be reviewed either tonight or tomorrow. And I've also informed the telephone company that they're pending review. And should they get approved, they'll be completed about the same time as well.
And they will also be able to be submitted 12 hours prior to the trial?
Yes.
Okay.
Are we appointing special master for those two other warrants or no?
Well, we want to clarify, Judge. What other records have you requested on these warrants? Because they haven't been produced. These requests.
I'm not going to go into too much detail because, like I said, they're not really formally approved. So I'll give you a brief synopsis. One includes CCTV footage, and the other is GPS location for someone else other than your client.
Yeah, we'd request the same thing, Judge.
And is there an objection from the state on that matter as well?
No, Your Honor.
Okay.
I just ask the court to consider again the timeline.
Yes, well, I'll make sure that everything is submitted in a timely manner. Should everything be approved and submitted to special master?
9 a.m. does nothing for me.
Okay. Anything further from the defense, please?
We do have other matters, Judge, but on this particular matter, as far as warrants and discovery, we're settled.
Okay. Yeah.
Just one more thing, Your Honor, if I may. 12 hours prior to the trial will be 9 a.m. I will not be available until 5:30 p.m. that day. I unfortunately work a very busy job. I cannot have the time to be doing things for this job when I am being at the other one.
Okay, well then I would suggest that your second and third chair assist, and I'll make note of that.
I
That they
would
need
have
to
suggested they
assist
assisted
as
a
well.
very long time ago.
Because it shouldn't. I mean, you have two other chairs that you shouldn't all rely on you.
There is one other chair, Your Honor. I will figure it out.
My apologies. Okay, so you have one other chair. Is there anyone else from your department that can also stand in to assist with the case?
I am not knowing. Many are conflict. And the ones that are not are having the very many other cases. It is not a problem of anybody but for me.
Would you like the defense to continue on with their motions, Judge?
Yeah, I mean, there's nothing I can do. The only thing I can suggest is having additional chairs be put onto the case if you're unable to make the deadline.
That's perfect. Thank you. I will
Um,
fucking produce
Or
prosecutors out of
have
my
your other
fucking
chair
ass.
step up to the plate. Mr. Hall, you can continue.
Thank you, Judge. First, we'd like a small matter to be sorted. We'd like to file a motion to strike Exhibit 5.2, I suppose we're going to refer to it as. That is the email sent by Judge Tarts. Now, it's our assertion that that particular email was first attached. Oh, jeez, I'm so sorry. I'm so sorry. Judge, I'm going to come up to the lectern so I don't. Jeez. Anyway, yeah, so this particular email was first included in the tampered with police report that the
Hold
court's already
on.
ruled on.
Where's 5.2? Because I did not calling.
It's on the most recent evidence submission on the main docket.
5.2 is a swab for me.
Oh, I'm sorry. It's 8.5.2. Sorry.
Okay, 1 second. 8.5.2. 1 second.
As you're looking at that, Judge, this again is an email sent by Judge Tarts. It's our assertion that this email was originally located on the altered police report that the court has previously ruled on. It's our assertion that the state had ample opportunity to resubmit this email in its own form, as the court had previously ordered, that they did not adhere to the court's time frame in the resubmission of this email, and therefore, as a punitive measure, the court should bar its admission because, again, they didn't adhere to your order with respect to the resubmission of this email. Again, originally located on the altered police report. So we'd ask that the court strike it from the record and bar its admission.
Okay, so if this was in fact a piece of evidence which was in the original filing that was amended, it was not resubmitted, then yeah, I'll have to deny it.
No.
Attorney, go ahead.
Your Honor, I do not see where it was stated that this evidence that was reverted to its initial form could not be submitted.
1 second, I will pull it for you. Line 16, the last statement. Lastly, I will allow the state to enter the exhibit. However, they have to do so by end of day today, at which point, should the defense wish to object to the validity, contents, authenticity, etc., they may do so at their leisure upon acceptance into evidence.
Your Honor, I believe that was in reference to the initial incident report.
So you asked for clarification on line 18, in which I provided clarification on line 19, stating that it was everything that was edited by Detective Rhodes. So anything that she added after the initial indictment filing was to be resubmitted.
It was my understanding that it was the file. As I state there, the state will also resubmit the initial unrevised version of the investigative file.
Give me one moment.
Yeah, thank you, Judge. I just want to clarify that we, of course, understand that the state's resubmitted the police report in its unaltered form, the interviews of Mr. Domingo, Baker, and Tarts. But this particular email, 8.5.2, it was located in the altered police report and then was never resubmitted until after the court's time frame.
It looks like you partially complied with the order on line 21. So you submitted 3 interviews, but you did not submit the text message. Rather, email. Apologies.
I believe that was part of the initial document.
I mean, I can look. Let's see if it was statement.
Your Honor,
Mm-hmm.
if I may, I actually made a copy or have a copy of the edited document, which you can compare to the current document that's on the docket. You can see that the font is different in the information that they edited onto the modified IR, if that helps you to see what was modified.
Is there objection from the state?
I don't know what she's talking about.
She has a copy of when it was edited, the original IR.
So it shows what was added to the original IR. And that additional statement is dated on the 1st of October, which is after the docket was posted.
It'll be very easy to get the affidavit from Mr. Tarts. He will say the same thing in the affidavit. You are more than welcome to strike it from the record.
Okay, if there's no objection, I'll hereby strike it. This
Thank
is
you, Judge.
8.5.2, correct?
That's right, Judge.
Okay, furthermore, go ahead.
Thank you, Judge. Other than the motion to strike, we do have. I'm going to walk up, not repeat my mistakes. I'm coming up to the lectern, Judge. I'm right up here. We have a motion to suppress multiple exhibits. Now, first, I'd like to present the arguments as to the suppression, and I can come up with a list if Your Honor would request after the fact.
Let's suppress
as to
the
specific
entire
exhibits that we're
investigation.
requesting be excluded and suppressed. But first off, I want to go a little bit into the background of this case. This all started on the 23rd of September, 2023. And pertinent to this matter is that former Detective Amara Krios conducted an illegal seizure of the defendant's person and her vehicle on the date in question. Again, the basic background facts of this particular matter are quite simple. The defendant was at the grave of her dear friend, former Governor Richard Starr, at the Sandy Shores Church. Thereafter, Detective Krios was called to the scene and conducted a detainment of Miss Jax. Now, previously in the day, Mr. Rochester had been kidnapped. His right eye and pinky finger had been removed. And after that incident, Mr. Rochester informed law enforcement. And I do have a quote, Judge, based on already submitted evidence. He said, based on his statement to law enforcement, the woman in the middle then took off her mask and she looked like Adrian Jax, but I'm not fully sure as my right eye was cut. He later says, after that, I passed out and don't remember anything else. And again, that's the statement submitted by the state in their incident report. The statement from Mr. Rochester. Now, Ms. Jax was identified again at the church in Sandy Shores at least 1 hour after Mr. Rochester was found. That's not necessarily in dispute. So it was a considerable period of time after Mr. Rochester was found by law enforcement, went through surgery, and then gave his statement. Now, when she was found at the church, it's non-dispute, but she did have dried blood on her hands. And using a completely unreliable identification, and without any reasonable suspicion, Detective Krios conducted a detainment of Miss Jax, and thereafter swabbed her hands and went on to analyze the swab from her hands, and then conducted a search and seizure of her vehicle, where she similarly swabbed the vehicle and found blood. And there are forensic reports that we'll sort of get to that are the findings of those illegal searches and seizures. Now, our motion is grounded in a couple of different parts. First, I want to touch on the unlawful detainment. Now, it's our assertion that the detainment that took place was unlawful. Because it was unlawful, anything that happened after the detainment or because of the detainment should be suppressed and excluded, both based on its exclusion for being a violation of the Fourth Amendment and based on the fruit of the poisonous tree doctrine. Now, it's our assertion that the detainment was unlawful, that mainly due to the fact that law enforcement cannot conduct a detainment, which is what this was, but upon a reasonable suspicion. Now, to have met the standard of reasonable suspicion, Detective Krios must have at the time had specific articulatable facts in conjunction with her experience and training as a law enforcement officer that would lend to a reasonable belief that Miss Jax was in the process of or was about to commit a crime. Now, it's our contention that at the time of detainment, Detective Krios did not meet the standard of reasonable suspicion, and because she didn't, the detainment was unlawful. Now, at the time, Detective Krios lent on two disputable facts in finding, in her opinion, to have met the standard of reasonable suspicion. First was Mr. Rochester's statement to law enforcement, and the second being the blood on Miss Jax's hands. Now, blood, even in large amounts, does not in and of itself inherently amount to reasonable suspicion. Now, there are plenty of lawful means by which a person can amass even large amounts of blood or blood stains on their hands or clothing. With that particular activity, I'm getting a call. One moment. Hey, I'm in court. Would that particular activity not inherently meaning or suggesting a criminal act has, will, or is about to take place? You know, a couple of things that come to mind: hunting, yourself being injured, getting your own blood on your hands,
This
helping
case
an
is
injured
I'm
person.
resigning after this.
These are
I am
all
done.
means in which a lawful act can cause blood to get on your hands or clothing, whatever else it may be, and it not to cause any belief, any reasonable belief that a crime is about to or will be committed. Now, in this particular case, of course, let me say, we humans are unable to discern the difference between lawfully and unlawfully acquired blood. It's quite simple. If you look at someone, there's blood on their hands, you're not going to be able to tell what they just did to acquire the blood. Is that something lawful, unlawful? So the court must understand that for there to be reasonable suspicion, blood can certainly be a contributory factor, but there must be other facts that, in conjunction with the officer's training and experience and the law, would generally lend to the reasonable belief that a crime is about to or will be committed. Now, that other part, the other fact that would have to be ascertained before reasonable suspicion can be found along with the blood. In this case, Detective Krios found that to be the statement made by Mr. Rochester. Now, Krios relied upon an unreliable and hearsay identification to effectuate her detainment in conjunction with the blood. Now, Mr. Rochester's identification was made to law enforcement just after he had gotten out of surgery, and amounted to essentially that he sort of kind of thought that an individual that was there in the scene looked like my client, but he wasn't really sure. That's what it really amounted to, this statement. This statement was made to other law enforcement officers, not Detective Krios. It was then communicated to her, and she relied upon a statement, an identification, if we can really even call it an identification, that was so unreliable and so based on hearsay, no reasonable person could have relied upon it. It was made by an individual that has a known history of going after my client, attacking her violently in multiple different cases. And ultimately, he holds a deep prejudice against my client. All of that Ms. Krios knew and ignored, and instead asserted that it was a reasonable and reliable identification, which it wasn't. There was no reliability in Mr. Rochester's assertion that my client was on the scene. And therefore, all she had was reasonable that she could rely upon was the blood on the scene and effectuating and meeting the standard of reasonable suspicion. Now, again, it's our assertion that blood in a completely unreliable identification does not amount to probable cause. Sorry, not probable cause, reasonable suspicion to amount to a lawful detainment. And therefore, again, the detainment should be found to be unlawful, an unlawful seizure. And anything that stems from that detainment should, of course, be suppressed and excluded. Now, that's the first part of our argument. We believe that this detainment itself was unlawful. But even if the court accepts that detainment was lawful, that it was based on reasonable suspicion, even if, of course, Your Honor, we find that it was lawful, the subsequent seizure, that being the swabbing of my client's hands, that was plainly unlawful, an unlawful seizure. Now, I suppose I'll go a little bit into detail as to what actually happened. And I suppose it is quite simple, but once detained, Detective Krios forcibly swabbed the hands of my client, took these swabs, took the blood off of her hands, again, the blood, and then later processed that. Now, it's our assertion that the swabbing of any individual's hands upon detainment does constitute a further seizure of that individual, and not just a temporary seizure as is allowed just based on reasonable suspicion under Terry and other case law. We believe that the actions that Detective Krios took did amount to a full seizure. By swabbing her hands, she conducted a seizure, and to conduct that, she needed probable cause to do so. And there simply was not probable cause to believe that my client had, again, broken the law. She was found many miles from the alleged crime scene. The only information that officers had at the time was that she had blood on her hands and that a completely unreliable source had vaguely named her as a potential suspect. That's it. That's all that they were working with at the time that they conducted this seizure. And that does not amount to probable cause. They needed probable cause to swab her hands because the only thing that they are lawfully able to do upon a detainment, both by precedent and by law, is, of course, prohibit the individual from leaving the scene and ask investigatory questions. Particularly if the court would allow me, under the general laws and ordinances, if you read the statute that governs the extent of a detainment, which San Andreas, it confines and restricts a law enforcement's abilities during the course of a detainment. And based on that statute, a law enforcement officer just acting based on a detainment of reasonable suspicion cannot do anything other than prohibiting the lawful movement of
So
an
what are you
individual
supposed to do?
and questioning that individual and conducting a Terry frisk. Those are the only three things: free to restrict movement, question, and frisk. That's the only things once you've met the standard of reasonable suspicion.
You're supposed to just let
This
her
was
go
not
home
an
and
arrest.
shower away
Again,
all of
they
the
did not
evidence?
have probable cause for an arrest. They only had reasonable suspicion. If the court finds that, again, that they did and that the detainment was lawful, we don't think it was. But assuming that the detainment was lawful, that's it. They only had reasonable suspicion to effect a detainment. They did not have probable cause to seize my client, to, again, swab her hands forcibly. And even if they did have probable cause, they are not by law permitted to do so when they are merely detaining an individual. Now, it's our assertion, again, as far as a probable cause goes. They need specific, articulable facts and evidence in order to have articulated, again, probable cause for a full arrest and or to have conducted the seizure of her hands by swabbing the blood. They did not meet that standard. They conducted the seizure. And again, even if those two former steps, even if it wasn't a seizure, or it wasn't a there was probable cause to conduct a seizure. When a suspect is detained, again, only three things by statute. Again, laws and ordinances under detainment. The only three things I can do: frisk, question, restrict movement. And because they exceeded the scope of the detainment by swabbing her hands, even if we were to assume that everything before that was lawful, but she was still only detained, again, their actions were unlawful. And the blood that was seized and everything stemming from the investigation, from the use of that blood and the samples, must be suppressed. And I can stop there, Judge, but we do have further argument as to the vehicles if you have any questions.
Well, let's start with just so that I know, as well as so that the state knows, which exhibits are you contesting?
I'm happy to come up with a formal list, Judge. It again is our assertion
A
that
and B.
a lot of this case was
Right.
based on the use of the forensic analysis that was conducted stemming from an unlawful seizure. Again, this is the blood from the car and her fingers. But particularly, I'll go through a list. We're going to ask that Exhibit 1, the report in and of itself, be stricken and suppressed because it contains material which, again, was obtained from a unlawful seizure, subject to exclusion. All exhibits marked 5.
That is the correct argument.
All exhibits marked 6. And Exhibit 7. And then upon the court's ruling, if the court does suppress these exhibits, we'd further, of course, intend to ask the state to produce a record of all evidence acquired through the use of this illegally obtained evidence. And then we'd later request that all of that be suppressed as well for fruit of the poisonous tree.
Okay, so for clarification, Exhibit 1, all of 5, all of 6, and all of 7?
That is correct, Judge.
Okay, continue on.
Thank you, Judge.
Actually, is this still going to be what you're about to continue with? Is that in regards to Exhibit 1, 5, 6, and 7?
Well, I'm happy to break this up and do this a couple different ways,
Mhm.
Judge. My next part of arguments have to do with the vehicle and the search and seizure that was conducted there. I'm happy to sort of stop here, and if state wants to respond, or if you want to break that up,
Just because that was a lot of information, let's let the state have a rebuttal.
I'm happy to do so, Judge. Absolutely.
Does the state need a little bit of time, or are you prepared to make a
Yes,
rebuttal?
one moment, please.
Yeah, take your time.
Your Honor, the state rebuttal to this would argue that extended circumstances in regards to that did exist.
You're asserting that probable cause or reasonable suspicion existed?
Definitely, the reasonable suspicion existing there, and the probable cause for the search was the extinction circumstances. If Lady Jack's walking away with a reasonable suspicion having the blood on her hands, it is reasonable to believe that she would have washed it away. Nobody want to be sitting with blood. If the police delaying the search and seizure of the blood DNA from the Lady Jack's hands and the vehicle, then that evidence would have been destroyed and removed from existence.
Okay, is that all you have as a rebuttal?
Yes, Your Honor.
Okay, I'll notate that down for you.
The state, Your Honor, if I may, will also assert that the state that Lady Jack's being found in very non-responsive, distant, shut down is described by many individuals will lead to a reasonable suspicion and add towards the probable cause.
One second, I'm just notating that. Okay, I've notated that down as well. What I'm going to do, just for the court record, I'm going to notate everything down. I will go deliberate, and then I will come back with a final ruling on all aspects of what is about to be argued and what has already been argued.
I'm sorry, I do have other arguments, if you will.
Yes, no, I was just making notation that I'm not doing anything right now. I just want to make it known that it's gonna be at the very end that I make my ruling.
Absolutely, thank you, Judge. Was there anything more from the state, or may I proceed?
By all means, go ahead and proceed.
All right, thank you, Judge. Yes.
You're welcome.
Now, state's argument as to the lawfulness of the detainment and subsequent search and seizure is grounded mainly in that this was an extingent circumstance. Now, this is plainly false. Now, an extended circumstance is actually defined by law in San Andreas, hopefully. We aren't just relying on pesky precedent. And by law, an emergency search can only ever be conducted if it requires the prevention of the imminent danger to life of an individual, escape of a suspect. And again, this certainly doesn't meet the statutory definition as required by the laws and ordinances. Now, as far as, again, this extended circumstance goes, it's quite clear, we assert, that there was not any reasonable suspicion to conduct the detainment. Again, if the court assumes that there was, and the detainment was lawful, we then move on to whether or not there was probable cause to conduct the search and the seizure of the blood. Now, the state is arguing that just because the defendant had blood on her hands, that means that officers can conduct any search and any seizure. They can search her person, they can swab her hands, and that simply doesn't meet an extingent circumstance. Now, at this particular case, we know that officers were attempting to connect in their minds somehow. It doesn't make any sense, but they were trying to connect Miss Jacks to this other kidnapping of Mr. Rochester. Now, that had already been resolved. Mr. Rochester actually had already gotten out of surgery and already give his unreliable statement of identification by the time that Miss Jacks had been found at the church. Now, her state of mind, whether or not she was groggy or how she was acting, frankly, has nothing to do with ascertaining whether or not she was presently, was about to, or is actively going to commit a crime. It actually works against the state in this matter. Her being more docile, shall we say, it generally You
Not
don't
to
find
docile.
criminals that are mumbling, that are actively committing crimes or are about to. It certainly works against them in determining whether or not there was, again, reasonable suspicion belief that she was, which she wasn't. Now, with that in mind, as far as extingent circumstance goes, extingent circumstance doesn't allow you to do whatever you want. You have to have a present understanding and actual evidence that there is an extingent circumstance to then warrant the what would be generally unlawful search and seizure of property. In this case, there wasn't. There wasn't any belief that Miss Jax was in any danger, or any other party was in danger. Mr. Rochester had already been recovered. I mean, again, she was far away from the scene. There wasn't, again, any belief that she was involved in that, or no
Yes.
reasonable belief that she was involved in this kidnapping.
Let us
And
argue the case
as
here.
far as any danger to any life, property, or belief that she would destroy evidence, I mean, again, no officer, not in the reports, not in any other evidence that's been submitted, has claimed that they believe that Miss Jax was going to destroy evidence.
You think she's
And
going
we
to
know
sit
that.
there with
They
blood on
never
her?
claimed that. They never claimed an extingent circumstance. They were basing their actions on, again, an illegal seizure. They detained her. They swabbed her hands because they thought it was lawful when it wasn't. And they proceeded from there. They needed to have probable cause, in our assertion, to conduct the swab of her hands. They did not have it at the time. Having a completely unreliable and unrelated kidnapping, and having
Hello?
yes, Judge.
Did you cut out?
Oh, I'm sorry. Where'd you last hear me?
Kidnapping?
Thank you. Yes, I believe what I said was having evidence of a completely unrelated kidnapping that had already been settled, and blood in your hands does not amount to probable cause. So the question again then falls to whether or not they had the legal authority to conduct a warrantless seizure of her hands without probable cause, just upon reasonable suspicion, and a detainment under reasonable suspicion. And the answer is they could not. They don't have any lawful authority. A detainment, again, I want to make quite clear, even if they had probable cause, even if it was an extingent circumstance, even if, again, they had reason to believe that this blood was unlawfully obtained, even if all of that's true, a detainment, which officers argue that this was just a detainment. They said it was only ever a detainment under reasonable suspicion. By law, they can only take 3 actions under this detainment. They cannot perform any seizure. They can only prohibit movement, question, and perform a frisk. By law of detainment in the laws and ordinances, those are the only 3 things they can do. They cannot conduct an extended circumstance seizure. They cannot seize based on probable. They can't do any of that. 3 circumstances, and I believe that Mr. O'Hagan has some arguments as well, Judge, if you will.
Want to hear you ramble anymore, actually, Oliver.
This is like the questioning
Your
on
Honor.
the stand all over again.
Your Honor, we'd also like to state that the expanded definitions of extenuating circumstances are not law in our state, which could be referred to United States versus McConnelly and Missouri versus McNeil. And neither of those are exercised laws inside of our state, as well as we'd also like to state that the officer, Amara Krios, during this detainment was off duty at the time. So this was an off-duty detainment.
No, she
And
got
those
on
are
duty.
all of our submissions, Your Honor.
Okay. Is there a rebuttal from the state?
Your Honor, I believe the Lady Creos get on duty before go to the graveyard. Also, the Twitter evidence where Miss Jax asserting she going to be picking up Mr. Rochester, leading to the officers' belief that she may be a possible involvement in the crime.
Okay.
Your Honor, we'd ask that the state admit into factual evidence based off the clock in, clock off logs and location of Amaro Krios at the time of clocking on duty.
You want me
Do you
to?
think you'll be able to?
We believe this is also referenced inside of her statement that states that she went to clock in.
Okay. Give me one moment.
It is very clear in her statement, Your Honor. She was filled in on the situation. She go to clock in and then went to Adrian Jacks.
Where is her statement? Is it in the initial IR?
Yes.
Thank you. Right here. The MCD incident report, correct?
Yes, Your Honor.
Okay,
Your
so
Honor, we
what
would-
is the defense asserting? Again?
Your Honor, it would be inside of paragraph 3
No, I'm reading
of the
it.
statement of facts.
Yeah. What are you asserting again?
We'll just asserting to the grounds of the detainment that it was done by an off-duty officer at the time as well.
From the way I'm reading it, she was off duty, but Charlie may have been on duty. So she left.
Be our assertion that Charlie was off duty as well, Your Honor.
Okay. Do you know, Attorney Kavanaugh, if Charlie was off duty?
It says here at the beginning, I was attending to a medical call in Rutting Canyon. I do not believe the officer would be attending a medical call if they were not being on duty.
One moment.
And then we'd ask for a point of clarification from the state if they're asserting that the detainment was done by Charlie.
You can clarify. I'm just reading.
I do not believe Lady Jux was officially detained until Miss Creel's returning to the scene on duty, where she's saying, I informed her she was detained.
So personally, I think this would be best clarified at the day of trial, because Amara Krios, or a detective, or former detective Sergeant Krios, will be attending trial, and she can be placed on the stand to validate these facts. I think that would be the best course of action to clarify this this part. Just due to the contingencies, as well as I believe that Charlie is as well. One moment. Yeah, I believe so. Anything further from either side before I go deliberate?
Yes, Judge, we do have arguments as to the search of the vehicle, which we again assert to be unlawful.
It is the same argument.
May I proceed?
Sorry, say it one more time. I was reading something.
We have arguments as to the legality of the search and seizure of my client's vehicle. We haven't presented those arguments yet.
Go ahead.
Thank you, Judge. Thank you. Now, as far as this case goes, we have, again, the search of Ms. Jackson's person. We know that took place. Again, it was unlawful. But we also have the search and seizure of her vehicle. The vehicle was completely searched. Again, more blood was found inside the vehicle, and then it was completely seized. Not only in that it was seized for the search to be conducted, but then it was afterwards taken from the scene and taken to be permanently seized pending investigation. Now, the search and seizure of this vehicle was quite plainly unlawful. Now, for a vehicle to be searched without a warrant, there must be probable cause to believe that there is evidence of a crime inside the vehicle. Now, in this case, even if the court is to rule that the blood, like the seizure of the blood from my client's hands, if all that was lawful, and the court believes that somehow it could be conducted just based on reasonable suspicion and the detainment that was conducted, even if we assume that all that's true, that does not allow law enforcement to then go a couple yards away and then conduct a search and seizure of the same individual's vehicle just because they want to. At the time, there was not any probable cause to believe that the defendant committed any crime
I will
or
not
that
have time
she
to
had
get
any, again, this blood that was found in her hands was evidence of any crime. They did not have that information. The defendant was not arrested on scene. And that's quite clear because they didn't have probable cause to believe that she broke the law. They could only obtain any of that probable cause, meet that standard, upon examination of the blood that was found on her hands. And they used the fact that there was blood on her hands, that they seized it from her, to then go search a car and seize it, pending investigation. For them to have done so, to do so warrantlessly, they would have to have probable cause again that there was evidence of a crime inside the vehicle, and they simply did not meet that standard at the time. And there is a case we'd like to bring up, Judge. That is the state of San Andreas versus Jake Teller. If you give me a moment, I can get the exact case number if you'd like. Give me one moment. It is case number 23-CM.
I've been here for 2 hours. I need to
Again,
be
this is
getting
State of San
affidavits.
Andreas versus Jake Teller. Now to sort of oversimplify and go a little bit into this case, this is a case where...
Sorry, can you repeat that for me?
No, absolutely. 2023-CM-40, the State of San Andreas versus Jake Teller. I'm happy to submit a copy in the sealed doc if you'd like, Judge.
Sure, yeah.
That should make things a little bit easy there. But yes, as I was saying, now this case, it's quite similar to this one. The court found that an unlawful search and seizure had taken place of the defendant's vehicle. Now, in this case, Mr. Teller, he had been found nearby several growing weed plants. From there, he was searched unlawfully. Law enforcement did not have any probable cause that he had broken the law, and so they immediately searched him instead of conducting any frisk of his person. They searched him, found evidence, and then thereafter they conducted a first search of his vehicle. When they did not have any probable cause, there was evidence of a crime inside that vehicle. Now, it's our assertion that this is a extremely similar case, and the court should apply this precedent that simply being found on the scene of a crime, even if there is probable cause to effectuate your arrest, that you have broken the law, which in this case there isn't, even if that is the case, law enforcement do not have transitory probable cause to then search your vehicle if it's there on the scene. There needs to be specific, articulable probable cause that there is evidence of a crime in your vehicle, that evidence must be searched, found, and seized because there is not an expedient time to obtain a warrant, of course, under the automobile exception. Now, it's our assertion that no applicable exception to the search and seizure that took place is applicable. Law enforcement didn't have a warrant. They didn't have probable cause to search the vehicle. and therefore all evidence that was found subsequent to that search and seizure must be suppressed under the exclusionary rule. Thank you, Judge.
Rebuttal from the state, please.
Your Honor, the state would argue that being around wheat, having your car around the wheat, very different than being covered in blood and having blood in the car. You can see blood on the steering wheel. It would fall under the same exigent circumstances as the swab of the lady hand.
Sorry, is that all, Attorney Kavanaugh?
Yes, Your Honor.
Okay, is there anything further from either side before I go and deliberate?
Yes, Your Honor. Thank you. Now, we want to make quite clear the automobile exception is the embodiment of the exigent circumstance doctrine, if we will.
Oh my God.
There is, of course, in a vehicle, we all know it's quite clear. There's, a readily available ability to move that evidence from the location. It can be hard to obtain warrants to search the vehicles. That's all to say that, again, the automobile exception, it is the embodiment of the extended circumstance. Law enforcement did not have an extended circumstance to search the vehicle. They needed to apply, again, automobile exception, have probable cause to believe there's evidence of crime inside the vehicle. They didn't have probable cause, and they conducted the search anyway. Again, all we're dealing with at the time, if you're Detective Krios and the other officers on the scene, if you're them, all you're working with is you have a suspect with blood on their hands. Their car is nearby. There is another kidnapping that took place where the unreliable, if we can even call him a victim, claimed to have seen an individual they're not even sort of sure was the same individual as the one you're dealing with on the scene. That's not probable cause. And it certainly is not probable cause to believe there's evidence of a crime inside this vehicle. That's not even close to the suspect you're dealing with. It's in a parking lot far away. So no, there is not probable cause to search the vehicle under the automobile exception. Again, we'd ask that you exclude all the evidence and again, suppress it, Judge. Give me one moment just to make sure co-counsel doesn't have any further thing to add. Judge, just one last thing. I'll say it from here. It's again our assertion that the interpretation, of course, of the automobile exception is that it should only be conducted when obtaining a warrant would not be feasible. It's our assertion that a warrant certainly could have been obtained in this situation. There was certainly time based on the detainment. A suspect can be detained for up to 60 minutes by statute before they must be released. So there's certainly time to obtain an emergency warrant. And because they chose not to, again, we'd like that to be considered. But again, there wasn't probable cause, even if there wasn't. They did have readily available the opportunity to get a warrant. They didn't. But even if they couldn't, there wasn't probable cause to search the vehicle and to seize it. So in conclusion of all this, Judge, I'd finally like to say, to run down a list of the points. The detainment was unlawful. There wasn't probable cause to effectuate an arrest. Even if there was, it was still just a detainment by admission of the officers. The detainment doesn't allow for the swabbing of hands, only frisking, questioning, refusing movement. The officers were not acting in lawful capacity when they attempted to detain Miss Jax. They were all off duty. They had to go and clock on duty to then get their law enforcement powers. We'd assert they were not law enforcement officers at the time that they detained her. They were citizens. They were performing a citizen's arrest, if you will, which is, of course, unlawful in San Andreas. They acted unlawfully in that regard. Thereafter, without probable cause, they searched her vehicle. And again, we'd ask that all this evidence that all comes from these illegal searches and seizures be suppressed. Thank you, Judge.
Anything from the state, please?
Your Honor, Lady Jax was found covered in blood in a remote location, it is very reasonable that she drive the car to get there. They have the reason to be investigate the car. They have the reason to be investigate her. Again, we will argue the extenuating circumstances.
Thank you, Judge. One more thing.
Oh
I
my
want to make quite
fucking
clear
god.
about this blood. Again, the court has to rule based on the information that officers had at the time. And officers at the time didn't know that this blood was at all connected to this other, to the kidnapping of Mr. Rochester. All they knew is that it was blood. You can't tell the difference between lawfully acquired blood and unlawfully acquired blood. And blood in and of itself isn't a criminal act. It doesn't equate to probable cause just because you have blood on you. And again, because of that, because they did not have probable cause just based on the blood, they didn't know how it could have been connected to other possible crimes, which again, we don't assert that it was. Because they didn't know at the time, they could not have effectuated probable cause to search the vehicle, even if all their other actions were lawful. So again, we'd ask you to suppress it.
Your Honor, we'd also assert that inside of city limits is
Oh my
not a
god, are you
location.
done assorting fucking shit?
Okay, give me 1 second, and I'll notate that.
Jesus fucking Christ.
Can you, Attorney O'Hagan, can you just repeat the last statement, please?
I am
it's more of a
tired of
statement. It doesn't
hearing
need to
them
go on the record, Your
talk.
Honor.
No, go ahead,
Okay.
put it on the fucking
All right.
record.
Is there anything else from the state?
No, Your Honor.
Okay, we're gonna go into a 30-minute recess. I don't know how long I'll be. I should be quicker than that. I don't know, but I'm gonna say approximately 30 minutes. We're now in recess.
Thank you, Judge.
Who is this?
You know, the downside of running a private law firm is like I wanted to do it.
Honey, I literally did a whole class. Do you want me to call Vivian, Phoenix, and Fing? What's the other one's name? Dylan up when we were in PDO and I was talking about transference? No, they're fucked up because they're idiots. Checking out.
Cyrus, come here. Cyrus.
You haven't seen the ghost table?
I'm very frustrated for many reasons.
Did you say you became a capitalist because you're a simp? It kind of sounds like you waterboarded and lashed Oliver until he said that. It's Axe.
I sent these requests on the 7th for these warrants, and the detective did not send them. I had to resend them. I kind of hope they throw out the evidence so I don't have to worry about it.
May I approach the bitch? Sorry, bench. I remember that. That was painful to watch. It was painful. What time's the case at, by the way? Let me double check that actually. Okay. Oh, I can actually attend the. Jesus, Oliver.
You
okay.
deserve
You
that.
deserve
Oliver,
that.
why are you punching everybody?
Delaney's face makes everybody angry.
Get out of here, loser.
What the
Go
fuck?
back to the gallery.
So rude. Let me look at my glasses.
There's only 3 attorneys up here. It's not you.
All right.
So
I've
rude.
come up with, after careful deliberation, I've come to a conclusion of how I'd like to rule. So I'd like everyone to hear from start to finish, because part of the ruling is going to seem one way where it's not. I will not be taking any questions, comments, or anything of that nature immediately after this ruling. After this ruling concludes, court will be adjourned, and I will see those that are involved and potential spectators on court on Thursday, which I'd like to remind all the parties that
You
court
will
will be
not see me
scheduled
in
an
court.
hour earlier than what is stated on the docket. We are pushing the trial back an hour, which we will commence at 8 o'clock Eastern. And like I said, all my notes will be updated to the docket
Yes.
within the next 8 hours. So without further ado, at this time, I'm going to be denying all motions raised at this pretrial conference by the defense. I personally find it premature to rule on the motions pending testimony from the former Detective Sergeant Amar Krios, who will be attending trial on Thursday, and can answer any of the questions that may be raised by the defense. This court believes that the proper procedure would be for the defense to raise the issue of the potential lack of reasonable suspicion and or the probable cause during cross-examination
God,
of
now I have to go
former
to
Detective
fucking
Sergeant
court to do
Krios.
this shit
Should the
all over
defense
again.
still believe there is no reasonable suspicion and or probable cause after her examination, they should re-raise the objections at the conclusion of her testimony in a shorter brief than that of today, at which point the court will then rule immediately there on the spot and proceed with trial, whether that be with the admission of evidence or the exclusion of evidence. That is the decision of the court. It's final. It's binding. I'll see you all on Friday, Thursday.
Before we adjourn, Judge, I do have one final matter.
Of course you do.
If the court can order the state to, since this is not going to be ruled on here and now, order the state to again provide a list or information as to what parts of the investigation in this case are based on the forensic evidence. The reason we wanted to get this settled now is because we need to determine what parts of their investigation were or were not based on the evidence that we believe, again, should be suppressed, so we can determine what is admissible and what's inadmissible.
Can the state comply with that?
Can the state comply within the now to the court date with that information in addition to everything? Yes, of course. No, I cannot do that. What do you think?
Just to reiterate, Attorney Hall, you're requesting that the state provide all evidence.
I am spending more time fucking responding to the defense than working the goddamn case.
The DNA evidence?
Yeah, Judge, so we are moving for all evidence that was at all based on the initial I gotta move to the lectern. Oh my, I'm sorry. I'm having some trouble today, Judge. Okay, so we're seeking the information for what parts of the investigation in the state's case and
I am
all
sure you
other
can
evidence.
bring it up in
We're basically
court.
asking what parts of the investigation and what subsequent evidence was acquired from what we believe to be an illegal search and seizure. So everything stemming that officers use to formulate and continue to investigate, stemming from the unlawful detainment and search there, and then the unlawful seizure and search of the vehicle. Because we believe that other evidence was acquired because of the illegally obtained fingerprint, the blood that was obtained from her person and
If
her
you
vehicle,
believe
and because
there is evidence
that
acquired
evidence
as a
would not have
result,
been,
then make your own
acquired
fucking
but
list.
for the illegal searches and seizures, that also needs to be suppressed due to fruit of the poisonous tree. So that's sort of why we wanted to bring this up here now, so we could just determine what is admissible and not admissible, rather than scrambling on the day of trial. But that's what we're requesting. We're requesting what evidence, again, is stemming from the illegal
I don't have time
searches.
to do that shit. I'm about to get contempt of court.
Give me 1 second.
Your Honor, the defense asserting they have a list of evidence they believe stemming from it. Let them submit the list.
Okay, so I can see the state providing the full evidence obtained through the swab, but I don't see why they would need to go through every piece of evidence.
Because you want to fucking waste my time.
And investigate which stems from the swab. It seems more like something that would lie on the defense to do due diligence with.
They have to assert establishment of probable cause, Your Honor.
Yeah, that's right, Judge. I mean, ultimately, we are asserting and plan to move for the suppression of all evidence that was obtained due to these illegal searches and seizures. And we believe that there is other evidence in this case that would not have been obtained but for the illegal searches that took place and the revelation that the blood ended up coming back to Mr. Rochester. We believe that significant parts of law enforcement's investigation, this case and other evidence, would not have been acquired again but for the use of that forensic data in furthering the investigation. This includes, say, the warrants that we debated earlier. It's our assertion that those are subject to suppression because, again, the fruit of the poisonous tree doctrine, they would not have been acquired but for the forensic data proving the link between Mr. Rochester and my client. And we need a full inventory of what parts of this case were actually affected by these illegal searches and seizures.
I cannot know the
And if we
mindset
don't
of the
have that, we can't
officers.
properly ascertain what evidence is admissible and not admissible. Again, because it all leads back to this initial detainment, these initial searches and seizures, and we need to parse out what parts of the investigation the case are or are not admissible based off that.
When do I have to? I have now.
Cool.
I am not going to do that.
Any rebuttal from the state?
If the defense wishes for that to happen, then I will motion again for the continuance. It cannot be expected to do that in the amount of time before the court case and to also be getting the affidavits and the depositions.
So the way I'm personally seeing it, is considering the defense is proposing the motion to suppress evidence, I would state that the burden falls on the defense to prove the initial basis for the suppression. Once that has been met, which I don't think it has been yet, because there's the pending conversation and testimony from Detective Sergeant Krios, I would feel that it would move to the prosecution to show through the preponderance of evidence that that it was obtained legally and should not be suppressed. But I think we're lacking that major point, which kind of ties all of this together, being Detective Krios's testimony.
If I may, Judge,
Of
I
course
want
you
to
may.
clarify that it doesn't seem there's much dispute between the parties as to the facts of the day in question. There's a question as to whether or not the individual was on the scene or on duty. And we're certainly fine with the court reserving ruling on that and hearing the testimony. We'd prefer that Officer Krios be here so we could have a full suppression hearing to determine that. But regardless, that is still up in dispute. We'll concede that. But the rest of this, the actions that were taken by the parties, there doesn't seem to be a dispute as to the facts with those matters. And those are the other facts other than whether or not they were on duty. That, of course, is an important part, but the rest doesn't seem to be in dispute. And we believe the court could make a ruling on the suppression, which would allow the state the time to, again, figure out what parts are or are not admissible.
When would you like for me to do that?
That would be our request. But again, we believe that it's quite important to determine, and we don't have that information.
Okay, well then have the
The
continuance.
state has it.
I will
The
be
state
happy
knows
to do
what
that.
parts of the investigation is based off of this. Again, illegal evidence. So either way, we need to determine what parts are, and we request that the state produce that information or the court make a ruling based on the facts that don't seem to be in dispute here today.
Give me one more second.
I am not going to do it. Not without the continuance. These are frivolous fucking motions by the defense. I wish I had something other than fucking water.
All right. I'm gonna let the state one final rebuttal, and then I'm gonna deliver my ruling on this.
I will not do it.
Does the state have another rebuttal or no?
It seems the state, the defense already having a list of evidence that they are thinking is being the I don't know what they're talking about. They already knowing the list of things. Why then they not present their list of things they are believing or to be from the DNA evidence? I am not going to do it. Even if you put it on the docket, you can hold me in contempt.
Okay, is that all from the state?
The state would also be happy to do this and compile their list, but I will again motion for continuance if they are wanting this so badly.
Okay, so here's my ruling. So number one, the motion for the continuance, as I've stated before, is denied just simply due to the scheduling issues. We don't have the capacity to push this case
I am
beyond
not going to do
Thursday.
it.
In regards to the request made by the defense, I'm going to deny it for the reasons I stated previously. In addition, to keep this case on track for moving forward on Thursday. So as I stated previously, this court is now adjourned. I will see you all on Thursday.
You will not be seeing me Thursday.
Sweet.
Real briefly. I'm going to bed. I'm tired. Good night. Have fun at your hearing. Sure.
Attorney Jax, Attorney Oxburg, my chambers, please.
Yeah, there we go. Bye, guys.
Yeah. Night.
Let's go, honey.
Bye.
I think you're doing great, Sonny. Sorry you're having to work so hard on this.
Good morning, Sunny.
I hope we get some more backup before Thursday.
I think she's went catatonic.
Oh, I don't blame her.
I do not have anything to be saying right now.
I know. I'm just saying.
Sonny.
I think you did really good, and I think you're gonna do great on Thursday. And I'm sorry you had to shoulder all this alone.
It would be really inappropriate for me to, help. But if you need a sandwich, I could do that.
Got lots of Korean food. Do you like kimchi toast?
No, I only eat the chocolate.
You only eat chocolate.
I mean, that's appropriate,
I only
about-
have cherry blossom milkshakes.
What about bingsu? It's milk-based shaved ice served with fruit jellies and fruit syrup.
No, that will not help.
I think you're doing great, and I think that maybe there is a lot of people kind of dropping the ball on you, but I think you're doing great.
My
Whatever
grade is
happened.
not being good enough.
Perfection is not going to be the goal here. It's going to be survival.
I don't think anyone's gonna blame you for how anything goes, one way or the other. But I did go ahead and let medical know to have that subpoena done as soon as they can. Oh, I gotta go see the judge. Hold on.
Who's the judge? Just kidding.
Sonny, do you want a hug?
No.
Okay, that's fair. I'm really limited in what I can do for you right now, but after this is done, come holler. We'll go do a ice cream night or something, okay?
Only if it is beer and chocolate.
Okay, I'll see if I can find some chocolate.
I'm hearing they made Ferrero Rocher ice cream.
Ooh, that's some fancy stuff. Yeah, sure. We'll see if we can scare that up and do that, okay? After this is all done.
Tons of ice cream. A swimming full of chocolate ice cream. There you go.
Oh yeah. In the meantime, go find somewhere comfy. Go hug your husband. Go do something, okay?
I don't have time for that. I have 2 hours to be submitting all the evidence and affidavits.
Do you not have anyone else assisting you in DOJ?
No, not really.
Go fucking kick Oxburg.
I have
He was
many
here.
things to do. I have to go.
I know. Okay. Stay safe, Sonny.
Have a nice day. Be safe. There you go.
You. My car is being gone. That is perfect. Shit. I don't know what they want them to do. The lady covered in the blood in the car. What are they supposed to do? Okay. Yeah, have a good day, lady. See if I even have the list of questions. Yes. I don't even think this is worth arguing in the court.
You are obstructing justice, bitch!
I don't know why you're sobbing to me. I am just standing in a room looking at documents. Thank you for the subs in my heart is happy. Shit. What is this? Oh, Winfred. The fucking Bob. It is T-Bob. Oh my god. I miss you, T-Bob. Oh shit. Please Winfred Breaker. No. She should be. Yes, it is a fucking circus. It would not be the circus if people did their jobs. There is not a date on this document. Yes, there is. 9/24. Oh, he get out the next day. That's perfect. Not very serious injury. I did not treat Mr. Strand anyway. Or Mr. Rochester anyway. Oh, nice. Either.
Baby,
Yes.
what's up?
I just want to hear your voice.
Oh, baby. That's actually really sweet.
Yes. It was not being the good day.
Oh? What's up?
I do not know that I can be this lawyer anymore
Why not?
because I am not being good enough.
What does that mean, you're not being good enough?
If you come to the court on Thursday, you will see.
Why on Thursday? What's up?
The court hearing is scheduled for the Thursday
For what?
for Lady Jax.
Do you not think you'll win it?
Absolutely not. The investigation is not done. The defense want to dismiss all the evidence. The judge tell me I should be pay attention to this case. And I feel like I am the only person that did be pay attention to this case. I'm doing warrants and questioning.
I'm sorry, baby, I don't...
It will be a waste of everybody's time.
I know what to say. It probably doesn't help that the lead investigator bailed, like from PD and altogether.
There are many people that barely. The first chair recused. The only supervisor available resigning.
Oh, well, that's unfortunate.
I will be honest with you. I am feeling she did maybe misleading me.
Who is sorry?
The lady Emma. I feel like maybe she misleading me in this case.
Emma, look, we all in PD think Emma is a fucking idiot. Don't worry about it. None of us, most in PD have had, like, Emma just, like, lied to us straight up about things that have happened or whatever. We don't really trust her one bit. We're in, Elio.
I had reservations about this case and the investigation that was not being done many days ago. I expressing my concerns to her. She tell me not to worry. The case not being scheduled yet. Don't worry about that. Don't worry. I'm in the courtroom today. I have never been more embarrassed. I have never been feeling more stupid.
Alright, well, we'll figure something out, okay? Like, it's fine, just, it's not your fault that you were given, like, a shit hand.
No. But I must go into a courtroom. Very high profile case. Many people there. We made looking more stupid.
Well, you think it's not a good case, you should just drop the charges.
That is possible.
It's your fault. You can put down. If he comes to you, say, "Oh, I'm sorry, but the person who initially did the case did a quite shitty job of it, and we have to deal with it." To be honest.
I did consider that, but I am believing that Lady Jax is being guilty of at least something. But if I drop in the charges, then she will walk free. And I do not know that I can be work with her or against her. And knowing the truth,
Well, baby, I don't know. I don't know what to suggest, honestly.
I don't know either.
In the DOJ's next, you should try. You should try and see if you can work for a private company.
I do not want to be the defense attorney.
I hate to say it, baby. These people might be the ones that are like, they may be the ones who like set you a little bit, you know.
Yes.
Seems like what you're telling me is that the DOJ is throwing you down the river.
I don't know everybody else being conflicted from the case. They cannot be helping.
Maybe. Baby, I'm doing some police work right now.
Yes, I understand. I just want to hear your voice.
I mean, look, hey, the good news is the keys are mine now.
Don't you mean ours?
That's what I mean, ours, yeah, it's our house now. It's not, we don't have to worry about random people coming to our house.
Oh, that is good.
The title is in my name now.
Oh, that is wonderful news. Now we can have this stuff, so I can cook the food. I buy the cookbooks.
That's what I need to figure out, because I don't actually, I still can't quite figure out to get, I'm not sure the stove is there, but I'll have to double check. But yeah, good, if you got cookbooks, that's great, we can make some nice food.
Yes, I want to cook for you. Maybe I will just be the housewife.
No, you can, you don't need to do that. Look, you're smart, okay? It just so happens that, like, all the DOJs kind of sold you down the river. Emma, I mean, if it's anything with Emma is probably a fucking, like, I don't even know. It kind of seems like she's, like, not really good at her job. So, that's from what I hear. I think you can, I think just, you know, it might just be a case of, like, you might have to find something new, you know? Maybe find, like, maybe have something that's, like, maybe work with defense lawyers a bit. I know you don't like the idea of it, but those people are, like, you know, they're very good at the court stuff, you know? Like, having someone who's, like, a really good lawyer, like, take you on is not a bad idea, I don't think.
Maybe.
Alright, I'll see you in a bit, baby, okay?
Okay.
I'll see you tonight.
Yes, good night. I really have to pee. I will be right back. And I will get spaghetti. Let me sit here. I will be right back. I forgot my spaghetti. Damn it. The fuck am I looking at? Oh, I put it all over here. Shit.
Error.
Shit, what is the song? There is not enough evidence here. I found that. Oh, fuck me. I know I'm not going to get that. My plan will be to make this lady look stupid as I will in court. Well, let's go talk to dog. Because I don't care anymore. Oh, hey there.
Howdy. How are you?
I have been much better.
Well, that's good. Good to hear.
No, being much better than now.
Oh, you have been much better. Oh,
Yes,
I'm sorry to hear that.
me too. I think I am now understanding why people will be shooting the fish in the barrel.
What do you mean?
I mean, the past 2 hours were wonderful.
Oh, I bet. Did y'all have that pretrial conference yet?
Yes, it went great. The case not dismissed without prejudice, almost dismissed with prejudice. The defense want all of the evidence to be dismissed or suppressed for to the poison history. They having no reason to be swabbing the lady hands or to be searching the car. It was unlawful search and seizure of Lady Jax covered in the blood.
That's what O'Hagan and them said.
Yes. I being in there alone, it was like the little birdie fighting the lions in the den.
I saw Miss Hunter around here earlier. Was she not with you?
No,
Yeah, I saw her. Gosh, probably been a few hours. But yeah, I saw her. She was working on that case as well.
yes, I think she reaching out to the witness to see if they come to the court. Which, by the way, will be the 19th. No time to get affidavits or depositions. I don't even think the clerk's ready to be doing any deposition between then. Discovery closing in the middle of the fucking day. I cannot be submitting documents in the middle of the day because I cannot be access the computer. So anything I am going to do either need to be tonight or tomorrow. No, probably tonight. I have warrants that were requested and approved on the 7th October. Still not returned with the information. Warrants still pending review on the docket submit more than a week ago. Still pending review. So I am supposed to wait in hope that they be reviewed, and if all are approved, that the evidence will be shared before the deadline for the evidence. The judge tell me in the court I should have did be paying attention, and I will be honest with you, if feeling like I am the only one that did be paying attention the entire time.
Yeah, I'd agree with that.
Nobody supervisor to help except Lady Emma. She resigning today.
Really?
And I will be honest with you. Maybe I get in trouble for to be saying this, but I feel like she maybe misguide me. I talked to her many days ago. I'm being concerned about the case and the evidence and not being complete. She said, do not be worrying, nothing to worry. The scheduler is not being done yet. The court date not here yet. She tell me not to worry.
When she resigned?
I believe the announcement today. I have never felt more stupid than being in that courtroom today. I am thinking this is not the job that I should be doing.
Why is that?
Because I am not being good at it. I am not being paying attention. I am not being prepared.
It's not a lack of preparation on your part. It's a lack of work being completed on the part of the police. Just the way I understand it. Is that correct?
But it is also my fault. I should have noticed. I should have realized when I doing warrants and investigating that this should not be go to trial yet. And now it is being too late.
Not too late.
How is it not being too late? The case will proceed, and they will be not guilty on any charge.
No, you still reserve the right to dismiss the charges. Let me do some research real quick, and I'll let you know in 1 second.
Yes, I can dismiss the charges, but then there will never be any charges. To be honest with you, I am not sure that I am caring, other than the interests of justice. Mr. Rochester clearly not caring. He posted into the docket. He say he not attend now or in the future. He not have time for this and is unavailable. You see, this state treat him not good, poorly in the past as a criminal. I'll not treat him like anything.
I'd talk to Mr. Lancaster or Miss Ashbrook, just generally speaking, and ask them their opinion on how you should proceed as far as dismissing the case. I think you reserve the right, the state reserves the right to dismiss the case because we're the one levying the charges. The court can't deny dismissal because we're the one who
No.
have levied the charges. So if you go in there and say we're dismissing the charges, they have no choice but to accept the dismissal.
It will
Now,
be with the prejudice.
but they'd have to give a reason. What would be the
They
reason
give
to
many
dismiss?
reasons today in court when I asked for dismissal without prejudice.
Okay, what
And
were
the
their
judge
reasons?
agree. Well, number one, there are many days between the 23rd and now that this could have been brought up, that there was plenty of time to be doing this, and that it is not the fault of the client that the investigation being not done.
Well, I agree with that. Or are there other reasons?
There are
But
so
if I'm
many
not
reasons.
mistaken, you were the second chair on this case when it was first assigned. Is that
That
correct?
does not matter. I should have did be paying attention to the case.
No, that would be the first chair's responsibility. That'd be his call. Now, whether or not you have the authority, or whether or not you have the say, yes, you do. But ultimately, it'd be the first chair's responsibility to make sure that the case is prepared to move to trial.
I did argue that, and that is when the judge telling me it is my fault. I should have did pay attention to the case. Again, I feel like I'm the only person pay attention to this case. And I feel misguided.
All right, what were there other reasons for not wanting to dismiss without prejudice?
Something about the time that Lady Jax be on the bail. It's not fair to her to be facing possible charges after be on the bail so long. They just focusing on that the state should have not be pressed the charges if not have the evidence.
Yeah,
Listen,
Miss Sunny, I think that's where you're going to have to get Miss Ashbrook and Mr. Lankowski involved. They know a lot more than I do about that, about how to proceed forward, especially with the lack of time that you have. I wouldn't say it's necessarily your fault or the fault of anyone here in the department. I think it's a blame of the slipshod investigation that had been conducted. Now, whether or not that's fair blame, I haven't read the docket. I have not read anything except what you've sent me, so I'm not fully apprised of what's going on this case, just aside from what you told me. But I think it'd be most appropriate that you reach out to Miss Ashbrook or you reach out to Mr. Lankowski, despite their involvement, and just generally ask them how to proceed. That there are some real issues here that need to be addressed, and unfortunately, there are no senior prosecutors anymore. There's no one to go to. But that'd be that's what I would do if I were you. But I don't know what to tell you. I think what's been done so far has been done, or what you've done so far has been what should be done. And just unfortunately, the investigation wasn't completed. And it's still ongoing the way I understand it. Is that true?
I'm sorry, I was not listening. Can you repeat, please? Repeat the question.
I was just inquiring if the investigation was still being conducted.
It was continued to be conducted because I asking for the additional warrants and information. Lady Roth says she's still working on the case. I don't know what she was doing. She says she's very tired. They want her to take the LOA. I expressed that concern to Lady Emma too, and she said not to worry.
Well, being tired is not an excuse when your testimony is needed. Is she even available to testify?
I don't know. Maybe. I don't even have questions for her.
Have you reached out to any of your subpoenaed witnesses?
Yes. I believe everybody except for Mr. Rochester and Mr. Torch can be being there. But no time to get the depositions. There is no court clerk being available. I do not understand why the court is believing that 2 days after the scheduler is done that it is good time to be set the court date. If there is witness not able to attend, there is not the time to begin the affidavit or to begin the deposition. Mr. Oliver Hall say, "Oh, that is unfortunate. Sometimes the witness just cannot be attending." He is very happy if witness not able to come. But my question is that truly justice? Is that truly seeking the truth if we are compromising the case in that way?
I agree with you. I think you're correct that your witnesses need to be available to come testify just as much as the defense counsel's witnesses.
They have no witnesses. Their plan is to talk over and to dispute all of the evidence. I am considered to be amending the charges to accessory. If the DNA evidence not thrown out, at least placing her on the scene, there will never be any evidence that she touching Mr. Rochester. But she is being there, not under force or threat or coercion. She's not being with him before, but she is being finding their location later. She putting on the disguise. The defense submitting no medical evidence or report that Lady Jax is in suffer from any condition that would cause her not to be remembered. But they will say that the information from Mr. Rochester is unreliable identification of Lady Jax, his injuries, and he just come out the ICU when they get his statement. When can I be changed the charges?
When can you change charges?
Yes.
Anytime.
Can I do it at the court hearing?
Up to yes. I have had that done before as well.
So, the defense, I am sure, will contest the amending of the charges. They will say you had many times to change the charges prior to the court hearing. If I change the charges, I will drop incitement. I will change from accomplice to accessory to the torture and mutilation, and attempted murder and organ harvesting. There's nothing that can charge her as accessory or accomplice to kidnapping. What are your thoughts on those changes?
I think we discussed that before. I think you're on the right. That it wouldn't be inappropriate to do it. But like I said, I haven't read the docket or anything like that.
Do you think a judge could advise me on when I can be changing charges?
The presiding judge.
No, it is Kingsley Murphy.
You can give it a shot.
I don't know this person. Hello there.
Hi.
Is this being the Judge Murphy?
Yes.
Thank you in advance for your time. I am being Sonny, the prosecutor for the state. I am sorry to be bothering you. I have a legal question.
Okay.
In the trial, um, when is when is the last moment that I can be amending charges?
It depends on the judge. A lot of times you would have to do that in discovery, which is up to 24 hours before trial.
I am waiting on evidence.
Okay.
That he say he will be try to get to me, and the evidence will be very important for the amending of the charges.
Okay. When do you go to trial?
The 19th.
Okay, well, he needs to get that evidence to you ASAP, otherwise you'll not be able to amend it unless he gets it to you that day. Then you can petition the judge during trial that you want to add charges.
I will want to change the charges and drop some charges, not add probably.
Okay. Yeah, you can petition the judge during trial of the amendment and the dropping of charges. It's not ideal, but you can do it.
You go for your time.
No problem.
Have this sunny day.
You too. Bye.
I don't know if that was helpful. I'm not worried about this.
So what did the judge tell you? Did she say anything? Hang on.
Shit, I need to make good choices and go to sleep. I am very cold. I don't know this. Gary. I am going to stay up way too late. At least my observation is over. So there is being that. I'm waiting for this person to be coming. It went okay. The lady said, we did good, but, you know, I am always harder on myself than other people. We definitely avoided some problems. Where's this person being? I need to go to sleep soon. I have to get up very early. I'll not eat dinner. Oopsie. Oh, this Mr. He look like a fucking pirate. Hey there.
Hello.
With this,
Gary Schumann.
I like the jacket.
Thank you very much. I like the skirt, I guess.
Oh, thank you. Uh, let me see. I am trying to think how to articulate. How good are you at cleaning up shit? Polish
It
dirt into the
depends.
diamond.
What's going on with the case?
Well, the case will go to trial on Thursday. Uh, most witnesses can come to the court. I do not think I can get that position for important witness. The victim, he don't care. He is never going to be available. There are warrants that are pending information from the 7th October. I have until the 5 p.m. on the... Shit, I am running out of time. Date of the trial, I believe, no, 12 hours, 9 a.m. So I have tomorrow night to be getting that information to post to the docket should it be returned to me. And 2 other warrants pending approval or judicial review for over a week. And then we'll have to get that evidence. To be fair, this should not have had charges yet. It is still the active investigation.
So I would just null process it. If I mean, if you think the case is not ready, just null process it. Drop the case.
What does
Continue
that
to
mean?
So you can nully prosecute. So you can deny to prosecute. Basically, motion to dismiss without prejudice, and it'll.
Oh, I tried that today. It did not work.
Why not?
Because the defense argue that it not being fair, that it is not the fault of the defendant for the case to be moving without having all of the evidence, still active investigation. She should not have been arrested. She been on the bail for so long, and it is a violation of her due process.
Well, it's not. So
Well,
what did the attorney or the judge say?
the judge said that the case will proceed within the timeline. Court will be on the 19th. I did try to have dismissed without prejudice. Of course, the defense motion to dismiss with the prejudice. The judge did not grant that one either. I asked him for the continuance. Unfortunately, the scheduler go out to November 4th, and not everybody being available anytime between the 19th and the 4th. This is the best date where most people will be being available, and the continuance would mean that she would be on the bail for more than the recommended time. This does not seem like the justice to me. This does not seem like seeking for the truth.
Well, have you talked to I'm just looking over the docket.
I also did ask for the deposition of 2 people, but I do not believe the clerk will be being available. I have never seen the
Well, that's not
Shumi.
an art. So, yeah, I mean, how does the frickin' judge not postpone it with all that in mind? That's crazy.
I do not know. Anytime I make a rebuttal, the defense have 15 more rebuttals to my rebuttal. I just give up. The defense is also wishing to have suppressed all of the forensic evidence. They saying that the Lady Jax was unlawfully searched and seized. They only having the reasonable suspicion that she committed crime covered in the blood sitting on the grave of Mr. Starr, Mr. Rochester, the person people being very concerned about, and Lady Jax says she going to meet them. They saying they did not have the probable cause to be getting the DNA from her or her car.
So where did they get the DNA at?
They got from the hands of Lady Jax, covered in the dried blood.
Okay, was that when she was being placed under arrest?
No, it is when she was being detained. On the night of the incident, she was found at the grave of Richard Starr. She having the blood on her hands. She being very quiet, not talkative. And she talking about to the Charlie Morgan or Lilith Indo, they confuse me, about the Rochester attacking Richard Starr.
Well, this case is not held by statute or the Speedy Trial Act, so they should really postpone this if you request it.
I requested many times. I request continuance. The defense wanting me to compile some sort of list about what evidence that we have that could be stemming from the fruit of the forbidden tree, the possible unlawful search and seizure of Lady Jax. I say I am happy to do that with the continuance, and the judge say no continuance. They are aware that it is an incomplete investigation and they do not care for the continuance because they do not want to have more evidence. The evidence should have been gotten before bringing the charges.
I want to urge the state to not cause undue delay with their submissions.
I did not cause undue delay with these submissions. We do the scheduler and then 48 hours after is when the court hearing will be. That is not the time to get affidavit deposition. And again, not the fault of the state. Warrants submitted, approved on the 7th October, still not getting the information. I will also state those warrants are ones that I writing and requesting, not the detective investigating.
Defense does not contest to having a pre. So you guys had a pre-trial conference, or?
If you could call it that. It was more like, did you ever see at the circus or in the movie where the lions be in the cage and they're like, arr? And then they putting the meat in there and they all pouncing on it. That is more like what it was.
What exactly did they say?
We spoke about an hour and a half about the evidence and the unlawful search and seizure of Miss Adrienne Jacks because of swabbing her hands and swabbing the steering wheel of the car. I tried to argue the extenuating circumstances. I deserve that.
Apologies. I don't know what he just said, but you have water and food, possibly.
Yes.
I bummed some off of you.
It's the only food I have left. It's very expensive Wagyu steak.
Really? You don't have to give me Wagyu steak.
This all I have, or dog biscuits.
Oh, I'll eat the Wagyu steak then. Oh, that's pretty good right there. Oh, you
I
probably
can't-
would have really liked that.
It is very sad. I am consider amending the charges or dropping them entirely. But if I drop in the charges, then that means that there will never be the prosecution of these charges.
Where did you motion to dismiss without prejudice?
During the pretrial conference. I did not do a public on the docket because I did not want to create a bad relationship with the Osofors. But
Well, the officer should have never arrested them without a complete case. I mean, is what it is. That's just being straight up.
yes,
So, I mean, sounds like they jumped the gun and arrested him when they didn't need to. Was the arresting officer even like MCD or anything?
yes, it is the
Oh
detective
my lord.
Ross.
Logan did this?
Yes. I have not been able to talk to her this entire time. I tried to be talking to her. She did not have the time for me. Do you know if I can post the medical records to the docket?
It depends. Whose records are you talking about?
Is Mr. Rochester the victim?
Yeah, if he can. I mean, technically, if it's evidence, I mean, but as long as you legally obtained
Yes,
it,
I did.
yeah, then you should be able to. I don't see why not.
Also, do you know when is the latest moment in a judicial proceeding where you can amend the charges?
The day before the trial is what I would say.
It is unfortunate because I have 12 hours before the trial, which really meaning tomorrow night for me, because 12 hours before the trial
Well, when they
is 9
ask
a.m.
you, at the, they're gonna ask you, what charges are you pressing? I mean, technically, theoretically, you could change it right there. And
Mr. Hall and Mr. O'Hagan, they will contest those charges.
well, if they need to, if they're not ready to face the charges and they want a continuance, and then they can file for one. You know what I'm saying?
The judge will say you had many times to amend the charges. Why are you wait till now? Undue delay.
Yeah, well, there's also.
But I have 12 hours before the case for to be submit the evidence from the pending warrants. And the warrants are very important to the charges.
Then that's what I would say. We're not able to serve XYZ warrant yet. So we need to push the trial. I mean, or we need to drop the charges without, or with no prejudice, or without prejudice, and we can revisit the case. They can be released off bail and everything, and then when we're ready to refile the charges, we can refile the charges.
I do not think you understand it. I did argue this for 2.5 hours tonight instead of working on the case.
I'd file an interlocutory appeal.
I don't know what that is.
That means the whole case gets put on hold and the Chief Justice has to rule on it. So, yeah, I mean, that's kind of, if you're at the point where you think you're probably going to lose the trial, then I think that's probably the last ditch effort that I would do. Is file for an interlocutory appeal to dismiss with or without prejudice. Being that the matter you're not able to serve XYZ warrants that you thought you were going to be able to serve, which are critical to the state proving beyond a reasonable doubt that the defendant is guilty. And if they don't accept that, that's kind of ridiculous.
Where would I go to do this appeal?
On the docket, you would just file for an interlocutory appeal. You'd articulate everything. And kind of just, Donald is going to really fight it because I know Donald. I trained him. So he's going to really fight it. But, you can't. There's no real legal standing to fight it.
What is interlock, or how do you spell this?
interlocutory appeal. Yeah, I would just throw up a bunch of I'd motion if that doesn't work, then I'd motion to I'd motion for a new judge because he's not really looking at anything that the state has to offer. I'd motion for a mistrial. There'd be a whole bunch that you can do.
The judge today saying the docket open the end of September.
But he can't bring up the dates right now. A statute of limitation or the Speedy Trial Act does not matter. So he cannot bring up dates. It's very clearly stated that the statute or the Speedy Trial Act is not in effect for this case. It will be if we refile it, you know. But as of right now, the Speedy Trial Act does not apply. So, like, it's a pretty serious case, so we need a lot of time for it, you know. But if anything, the only people I'm really kind of mad about is the MCD detective who filed this, because I mean he shouldn't have done that if if the case wasn't ready, if he hadn't served all his warrants, or if he thought there was going to be any more evidence available.
Can you help me articulate an interlocutory appeal?
Yeah, give me 1 second. I'll write it right now.
I cannot punch this man. It will not punch him. I will need some food before I starve to death. I am being hungry. I give him my food. Did you say before a ruling on the motion to dismiss without prejudice that he speaketh with Mr. Young?
Hold on, let me write this, and then I'll send it to you, and you can let me know what you think.
Okay.
Are they search warrants or are they just normal warrants?
The one approved is a search warrant for the GPS triangulation of Lady Jack's phone on the night of the incident in question from 7 to 8. The ones pending are the CCTV of the Howick hair store and the GPS location of Rochester phone from the night in question between 7 and 8. The pending review since I believe the 11th October. The one for Lady Jack's GPS was approved on the 7th October.
Yeah, send me all of the pending search warrants and when they were approved. Like, put it in the channel, the email thread we have.
I do not have access to the actual warrants. I just have communication from Lady Rhodes of the one warrant was being approved on the 7th October.
Who has access to the warrants?
They are the sealed warrants.
Who are they sealed with? Like, if you're the prosecutor, you should be within the sealed. Like, you should be within it.
I do not know. I have a copy of the information within the warrant because I wrote the warrant.
Is the service of that search warrant, is it outside of Adrian's control, or do you think she's trying to tamper with it, or what?
It is with the IT department, the phone company. This warrant, signed by the judge on the 6th October. I will state that I did first request the dismissal without the prejudice, and then for the continuance. And the judge saying he will pressure for the warrants that were requested to be reviewed and for the IT department to return the information prior to the start of the trial.
I just made it longer. Read it again. Let me know what you think.
Um, um, oh shit, where is my document? I will say, um, that the victim's right to closure, I believe the defense will argue, as the victim posts to the docket, I will not be able to attend and will not be able to attend in the future. I have no time for this. Unavailable.
Well, so organ harvesting. Who was that? Who was that organ harvested from?
The victim, Mr. Rochester.
So Mr. Rochester doesn't want had to have anything to do with this.
That is correct. Yes, I do not appreciate the way the state presented themselves toward me in the past and present by treating me poorly as a criminal falsely. If I say I will not come, that is final. Good luck.
Well, then we can't even prosecute this without the cooperation of the main victim. I mean, you can't like. I mean, the only time the state is allowed to represent, the only time the state's allowed to represent a victim without their consent is during a domestic violence situation, because at that point the victim is not the, you know, the male or female or the partner, it's the state. So, you know, the shit it shifts onto the state as the victim. So if we don't have a cooperating a cooperating victim, I mean, it's very, I mean, we cannot, we're kind of playing cowboy right now, because who are we trying to get are we trying to get closure to? What kind of job are we trying to do if the person doesn't want to, you know? You see what I'm trying to say? Like, it's just
The only
we're
thing
fighting
we
for
have
someone who
from
doesn't want us to fight for them, you know?
Yes. The only thing we have from Mr. Rochester is his initial statement given to the police. The only other thing to be fighting is, I don't know how to articulate this. The state public defender, after not guilty outcome she won in court, allegedly go and assist in the attack of the accused against her.
Can you reword that? I don't know what you mean.
I will put it bluntly. Miss Adrienne Jacks is the state public defender, very known attorney, person in the state. She is very well aware of the law in the court proceedings. It was the trial of Mr. Rochester where this all stemming from. Mr. Rochester, his warrants get dropped because I don't remember why. The warrants get dropped and the case against him get dropped. Mr. Rochester was alleged to have attacked Miss Jacks, alleged to have murdered her best friend, Mr. Starr. Many people saying Lady Jacks, she shutting down, acting very different, dissociating. She disappearing from the court, going, change the car, change the clothes, change the hair, and ending up with the blood of Mr. Rochester, the accused, on her person. She telling people at the court, where can I go where I cannot be heard screaming in frustration? She texting the friend, if he founding not guilty, you will have to get me out of here quickly.
Why didn't y'all charge her with abuse of office?
In what way would it be abuse of office?
So abuse of office, being that she's the public defender, okay, is using an office of government employee or law enforcement to benefit one another through the exploitation of privileged information or using one's powers to unjustly inconvenience, threaten, or coerce another person using tools or powers only accessible to government offices or law enforcement officers, i.e., application of repeat offender status. Abuse of office charges will be investigated by the U.S. Marshals. So if she did not like a outcome of a case, and you think that you can articulate, if you think you can articulate that and make a case for that, then
she did not use her office because she did not like the outcome of the case. Instead, she go and meet with people who kidnapped Mr. Rochester to watch him be tortured, to watch him get finger cut off and cut up, maybe even participate. She not abuse the office. She break the law.
yeah, but I'm trying to. So she didn't like the outcome of a court case, correct? Is that what you're saying?
She was very upset. It was very clear, Lady Ashbrook telling her before the court hearing, I was here for this, that if the warrant against Mr. Rochester is dismissed and invalidated, then he will walk. Miss Jacks get very upset and walk away to the back of the courtroom with Lady Lilith Indo. She telling Lily, where can I sit so people not hear me scream in frustration? She texting Lily, if you walking, you will have to take me out of here fast. At the time the court ruling was made, it is noted by Lady Indo, who is with Jax, that her complete demeanor changing, she dissociating, non-responsive, shutting down. She leave the courtroom. She tweeting at Mr. Rochester, who wanting a ride from her. She say, "Sure, where are you at?" "At the prison, of course." "Yeah, I'll be on the way." Many people worry. And she leave in the court, telling Tobias she going home, but not going home. Mr. Domingo following her, where she went to change the car, and the clothes, and the hair, and then, still not going home, Mr. Torch wait for her at home, she not come to there. He call her, she say, "I am at the wear and tear, and then I going home." And then, after Mr. Rochester is abducted, Mr. Torch seeing her going north on the freeway, the same direction Mr. Rochester abductors taking him, seeing Miss Jax in the car, being distant, dissociate, wearing not her hair, wearing darker clothing, in the same white truck Mr. Domingo see her in. And the next time anybody seeing or hearing Lady Jax, she is at the gravesite of Richard Starr, the alleged victim of Mr. Rochester. She is having the blood on her hands, the blood on the steering wheel of the car.
And the guy and the blood in which was
Return to the
Rochester.
victim, yes, Mr. Rochester.
I'd really like to talk to Mr. Rochester.
Mr. Rochester not interested in speak to anybody.
Yeah, well, maybe they got to him before we did. And they're intimidating a witness.
That is a very big allegation.
Well, when you've been doing it as long as I have, there's things called assumptions that you can make. When you have someone who has had their organs harvested and is not willing to testify in court, I mean, you can make a educated guess on why. I mean, put yourself in that situation. Why would you not want to prosecute someone if you were a victim of a case who just harvested your organs? It's because you feel like it might happen again, or you're scared. I mean, let's change the subject to a domestic violence case. Why would a individual who's married to someone not want to go through a domestic violence case? One, obviously because they love them, but two, they still want to live with them, and if they go through with a case, it's just going to be further abuse. So, if we look at this case, I mean, was there protection orders? Was there temporary protection orders filed against Adrian Jax and the other accomplices?
I do
with the
not
victim?
believe there are any positively identified accomplices. There are suspected skinners to be involved in the kidnapping of him and the attack on his person.
Yeah, so I mean, theoretically, logically speaking, and I've looked at this case for an hour that we've been talking. So I mean, it's not something completely outside of the woodworks. Like it's a probable. I mean, it's something that could have probably happened. So, I mean, at the end of the day, you cannot represent someone who doesn't want to be represented. Like, you can't force someone to want to, press charges against someone. If he's not wanting to press charges, like, it is and cooperate with the investigation, cooperate with the trial. I mean, we're almost kind of, I mean, we're kind of doing some cowboy shit right now. Like, we're kind of just taking the law into our own hands, if that makes sense, in my opinion. So, I don't know. I definitely think that this guy is getting coerced in some way, possibly. Because I don't know, if I was a criminal, right? And you're the person that can send me to jail for the rest of my life. If I'm out, I'm going to try and find you and intimidate you and make it to where you don't testify against me, right? Or I'll have someone do that on my behalf because I don't want to go to prison for the rest of my life, or I don't want to go to prison at all. I don't want to lose my position in the DOJ, et cetera, et cetera. So, I don't know. That's just my opinion. Hopefully you don't take any offense to it, but that's just...
No, I am not being offended, but I know very little about Mr. Rochester and the case that was being against him. It was told to me that Mr. Rochester is suspected in the attack of many Department of Justice and legislative persons in the state. I almost am believing that Mr. Rochester, believing he get what he deserving, and he will move forward and continue doing what he is doing because the charges against him were dropped. He feeling like the winner.
Wait, can you repeat that? Sorry. The last part of that.
Mr. Rochester, which part?
Did you ask me a question at the end of that or something?
No, I don't think that was the question.
Oh, okay.
I think that he is at peace with what happened to him, and he will maybe continue to do what it was alleged he doing in the first place.
Man, do we have Mr. Rochester's number or anything?
Yes.
What is it?
Let me look. Oh, it's right here on this warrant request. It is, I can't even read anymore. 838-363-4440.
He's not awake.
No.
Well, I mean, hopefully, I don't know. So what do you want to do?
I do not know what is the right thing to do here. It is more than just the attack of Mr. Rochester, in my opinion. It is a person in a position of power taking the law into their own hands and continue to be in a position of power. But without Mr. Rochester, I do not know. Does that make sense?
Yeah, I'm looking at the racketeering or RICO definition right now to see if we can hit it with a RICO charge. I don't know. It doesn't seem like we can. Unless, I don't know, maybe you can articulate extortion, but there'd have to be a pattern of it.
No, I don't believe that will work. Which is the only reason that I am...
Yeah, because if you get, like, I understand what you're saying at 100%, but if we don't have a charge that can shift the victim from roads to the state, then like it's hard to say it's more than the roads incident. Does that make sense? That's why I really just want to get this dismissed without prejudice, and then, you know, give her enough rope to hang herself with, and as soon as she does something again, I mean, that's pretty, well, I don't know. Or we can, during the time that it's dropped, we can reapproach the victim and see about getting them to change their stance. But we have 90 days to charge on the attempted murder. Is it first or second degree?
It would be first degree.
Yeah, so we'd have 90 days for that charge and 60 days for all the rest of them. You know, the torture and stuff like that.
There is no evidence of the incitement. In order to prove that, you have to get to the phone records or the bank records.
Yeah, honestly, instead of a criminal docket, this should have just been a sealed warrant. You know what I mean? Like, they should have just filed a sealed warrant when they had all this evidence that they have right now.
Yep.
And the return of that warrant would have made this case
Get
so
ready, go
much
to sleep.
stronger. Like,
No, I do.
I don't doubt there's probable cause here, but when it comes to proving beyond a reasonable doubt, I mean, I think they've really messed up. I think the major crime divisions did. And that surprises me because normally, like, they're very good about that, you know? I work with them all the time. They're always sending me emails like, hey, do you think we have enough here to blah, blah, blah.
I wish they asking about this before file the charges.
Yeah, I don't know. I feel like we need to get with MCD command and be like, look, if it's a big case, like, y'all need our approval before pushing it, or we request y'all to get her approval or something. Because yeah, they done screwed the pooch on this one, in my opinion.
Part of the problem here too, the DLJ supervisors, everybody conflict.
Yeah, I get that, but at the same time, I don't know. We all have different approaches. You know, I'm technically a civil prosecutor, so, but I'm telling you right now, I can do criminal. Like, I never lost a criminal case, and I've been DOJ for over a year now. The only criminal case I lost was a freaking bench trial, and that was we did it because it's pretty much a joke. And I trained the defense counsel that we're going up against right now when I owned Schumann Law Firm. So they know what they're doing very, very well. Ronald was my second in command of my firm.
Do you want to become to court for this one?
I mean, I will be in Liberty City tomorrow, or else I definitely would. But I tried the other day, like, trying to message in the email thread, trying to figure out what was going on because I was requested to. But man, it looked like y'all just had so much discussion. I couldn't go back and read everything. It was just too much. I mean, I don't really have a lot of time on my hands like I used to because of Liberty City. But
I am very understanding this. It is very late for me.
yeah, I mean, I'm good like tonight. Like I can be on, for another 10 hours. It really don't matter for tonight. But I'm just saying in general, like, I don't know. I can't sit and tell me about a case or something that works. But like sitting there and reading a Discord email chain of like 900 messages or however many messages are in this email chain. Yeah, I can't sit there and do that. I don't have the attention span like I used to. Does that make sense?
Do you think I should file for this interlocutory appeal?
I mean, you can try, but I think that it's probably going I think you should probably dismiss the case. I definitely think the case needs dismissed without prejudice. Even if the case does get dismissed with prejudice, if you can find another crime to add to this, I mean, you can file again. Does that make sense?
Know what other crime would be added to this.
That's what I'm saying. That's what, like, there's a lot of tools that MCD has that they need to start using. Like, they need to put small charges, like, that they file on the side and not charge it initially. And that can be an emergency charge to file if a case gets thrown out. Because as long as there is additional evidence that you're adding to a docket, technically it's a different case. So it's not just a, dismissed, you can still file that case. Does that make sense? So like if more evidence came about or another charge was added, they can't go, oh, well, this case was dismissed with prejudice. It's like, no, this is a separate case. There's additional charges. Like, we're trying to prove another case now. So it's a completely different, thing. It's a strategy that they use in Liberty City a lot. So it's just, they need to start kind of thinking outside the box because these fucking defense attorneys are, and we're getting kind of schooled, in my opinion. Like this, Donald is taking this case exactly how I would do it. Donald and Oliver. So, but I guarantee you right now, they went up to that guy and they freaking intimidated the crap out of him, or cut him some type of deal, or they have some type of. And even probably what's going on is Donald is Logan's representation, Rhodes. And so they probably have a conflict that they shouldn't even be. Like, we should look at prior court dockets and see if O'Hagan law firm, Rochester. We should see if he's ever represented Rochester, if he's got any prior dockets. Because if that's the case, then that's a huge freaking conflict. So.
What's up? Me too. Not really.
All right, y'all. I'm gonna sit by the office for a little bit.
It is very difficult to be get in contact with the person that not wishing to be contact. I am aware there was a case against you, but the facts of that case, I do not be knowing. And to be honest with you, even if you did commit those crimes, that is not the concern of Sunny. That is not the way for justice to be, in her opinion. It is not an eye for an eye. It is the matter at hand that matters now to her. It is 1 in the morning. Sonny is starving. I need to get up in a few hours. What is your thoughts? To be try the interlocutory appeal or to be dismissed the charge or to be changed the charge?
Is the detective on right now that filed this?
No.
Any command of detectives around MCD?
No, I do not believe so. I have only been see the detective one time. She say she not talk to me at that time. She not want to be talk about the case. She do respond to the emails. Well, probably not right now. Ego twisted. I cannot stay up much longer.
All right, read that new one I just wrote. Give me 1 second. It'll be in my head. What do you think of that?
In the first paragraph, it says during the discussion, the state moved to dismiss without prejudice. After being informed, we will not be allowed to file for a continuance. The request to dismiss without prejudice occurred before the request for the continuance. Perhaps that is the fault of me. The defense will argue we are trying to get more evidence against their client and will object. In the judge saying he will work with IT department to get the search warrant approved and get the information to us as soon as possible, and that he will push for the other warrants to be reviewed.
All right, I reworded it a little bit.
We are not only waiting for cooperation from the phone company, but also a review of the warrant submitted. And if approved, we will need to wait for IT phone company and the store to be providing that information as well.
So there's another pending search warrant?
There are 2 search warrants that are pending judicial review. There is a search warrant for the GPS triangulation of Mr. Rochester's phone, and there is a search warrant for the CCTV footage of the hair on Halwick.
Missions?
Are they what?
Court? Do you know the day that they were submitted to the court for review?
It should be in the tracker. The hair on Halwick will submit on October 11. I should the other one have been. It took a lot of work to get those warrants to meet.
All right, the state will be seeking a motion to reconsider based on our pretrial conference discussion. During discussion, the state moved to dismiss the case without prejudice. Blah, blah, blah. The discussion was prompted by the existence of an active pending search warrant or pending active search warrants that have yet to be hold on.
It is not just the phone company, it is the judicial branch not reviewing the warrants. I will also note that the judge has allowed the late submission of the warrant information up to 12 hours before the court proceeding. You see, he tried to accommodate, but I cannot be being available at that time. He said, maybe somebody else can be available. But that is not enough time to be reviewed that evidence and prepare for court 12 hours later.
Y'all need anything to eat?
Yes, absolutely, I am starving. I give away my Wagyu steak.
All right, there you go, madam. I'm gonna hide in the closet before the storm gets here. I'll take
Oh
cover.
shit, I forgot about that.
Yeah, once it passes, I'll be back around. All right, y'all take care. Have a sunny day.
You too. Shit, these dog biscuits, will they go bad? Oh. Good. I wonder can I eat them?
How many hours until the court date, or the court from right now?
It is,
Or in, what? Yeah. How many?
maybe 40. It is at 9 p.m. Eastern Standard on the 19th.
So like 24 hours from now, or over 24 hours.
It is 43 hours and 25 minutes. Thank you, Google.
43 or 34.
43. He said discovery will close at 8 p.m. Eastern Standard Time today.
Okay. So how many hours till then?
42 hours and 25 minutes.
All right, read that.
I do not know if this will make me any friends in the court.
What do you mean?
It might be make the judge upset.
I mean, what do you have to lose at this point?
That is fair. Shut up, dog. I will post this. Before I go,
If you hold on, if you want, what I can do is assign myself to the case and post it. And if it doesn't go our way, I can recuse myself. That way, it doesn't like it doesn't affect. Like if you end up going to trial tomorrow, he doesn't look at you negatively. He'll
Shut
just
up.
look at me negatively. And I don't care what he thinks about me, honestly. But I can assign myself to this case real quick. Third chair, or whatever chair you guys are at this point. Fourth chair. I don't know how many you have assigned to this. But
Well, the first chair recused himself, LOA. The third chair resigned. Fourth chair, Lady Hunter. And me, previous second, moved to first. There is two I thinking right now. Me and Lady Hunter.
alright, let me just assign myself to this and then I'll post it. And then that way, again, it's if he gets upset about it, because I see what you're saying now, then it's at me, not you. So it doesn't affect your trial tomorrow.
I'm
Does that make
sure the
sense?
defense will object to the assigning
Oh,
of a
yeah.
new chair.
Oh, no, they can't object to that. You can't object to counsel being assigned or not. There's a case law on that, so.
You would be surprised to how many things they are objecting to.
Yeah, they can't object
Actually,
to that.
probably not.
I guarantee you, if they see me assigned, they're going to have a field day and they're going to want this to go to trial because they're going to want to go against me. I just know how they are. I doubt that they'll object to me being assigned.
You deserve a death stick. I hope it was tasty. I like your signature.
Thank you, thank you.
I'm putting all of my documents and investigating in the tracker. What is your opinion on the suppression of the forensic evidence due to the unlawful search and seizure of Adrian Jax?
If she was being placed into custody, I mean, it's not really unlawful search and seizure.
They're saying that at that point in time, she was only detained, not under arrest. They did not have the probable cause to be searching and seizing her. And that the blood on the hands, there are many lawful means of obtaining blood in large amounts on the person. It cannot be discerned the blood was lawfully or unlawfully acquired. There are no other facts present to lead to the reasonable belief that she committed the crime. And they are
Well,
relying on
given the exemption of, so the Fourth Amendment has exemptions, okay? One of the exceptions is exigency, okay? Exigency being in the possible destruction of evidence. So
I
if
argue
they,
that.
yeah, if they even had any reason, if they had any, I mean, at the end of the day, what did they do to violate her rights, or by going and getting blood off of her? Like, that's not really violating someone's rights. Now, if they would have went into private property and they would have done X, Y, and Z, or gotten a DNA swab of her, you know, that's a different story. But getting someone else's blood on the scene of a crime, I mean, it's not a violation of the Fourth Amendment. There's cases which, again, aren't really recognized by this state, so to say, but if we go and we appeal this case or that comes up, like, we can take that all the way up to the San Andreas Supreme Court, and we can make our own case law on that. But at the end of the day, if there was exigency or they had any reason to believe, I mean, I think they're in the right. If they had to go and into, you know, like, so where was the vehicle parked? Was the vehicle parked on private property? Then, if it was, they can articulate towing the vehicle. And if they're towing the, yeah, if the vehicle was on,
at the graveyard on Route 68.
yeah, so private property. So the vehicle was not going to stay there, so they had every right to impound the vehicle or tow the vehicle. And prior to towing a vehicle, it is department policy to conduct a vehicle inventory to ensure that no property is misplaced, misfound, or anything like that. So during the course of a vehicle inventory, if they obtain said evidence, I mean, it's lawful. So
They also argue a case precedent here, the state of San Andreas versus Jack Taylor. I kind of stopped listening at this point because there are so many rebuttals. They talk for hours about this, to be fair. Something about him being in a wheat field and they searching him and his car. But I argue that being covered in blood at the gravesite of a potential alleged victim of the victim in this case is very different than having car near a wheat field.
yeah, even a weed field, if as long as, I don't know, like, I think it would just, if this case can get rescheduled, I don't mind coming on the case with you and helping you out. But I mean, at this point, the only thing we have to really worry about is getting this case postponed or dismissed without prejudice. I wouldn't really worry about anything else right now. But if this gets denied, then we're pretty much, I mean, the case is pretty much gone. So
If they deny the motion, Then to dismiss the charges?
Yeah, I mean, in my opinion, I feel like the case would be without. I mean, unless the freaking just victim shows up at court tomorrow. I mean, you know what I mean?
Not happening.
If I could, I honestly feel like if I can talk to this guy, I think I can convince him to show up. You know, but at the end of the day, if he's not around in the city or what, like, I mean, that's not going to be possible. So I don't know. I can try to email him if you want me to. See if we can get him in the city or what. I don't really know.
It would
Here,
be.
let me try to email him.
I do not think he will be respond by the email. I am just thinking that. Dog, I know I need to be asleep right now. I have to get up in like 4 hours and drive an hour to work and get a chair thrown at me and scream at that. But here I am, not paying attention to this fucking case. Shit. What is this one saying? Oh, Mr. Lankowski should be being there. It will not matter. Thank you for the raid. My heart is... it is the very long day today. It's sunny is very not sunny. I am very stormy today. And we will be going to sleep. Thank you so much for this subs. My heart is so happy right now. It does not sound like it, but it is. I am not mad at people. Oh, see. Sonny very mad though. And Sonny having some very serious allegations against some people. We will see what happened with that. I do not think she will be making any friends. Not in the Department of Justice. We will see though. I have a 8-page document of questions for all of the witnesses. But this case should not have been pursued this time. When did I get assigned to this fucking case? How long ago? Let's find out. All the way to the top. The 30th.
All right. Well, I sent him a email. Hopefully, I don't know. Maybe he'll respond.
Maybe. I don't know. I tried to call him. He never been around when I could be calling. Thank you, Mr. Schumann. If nothing else, at least for the help tonight. If they're denying the motion, I will most likely just dismiss the charge. There is no reason to put everybody through the court case. It is the very long possibility to maybe prove the accomplished charge.
Yeah. At the end of the day, if you feel, you know, like when you get there and you don't feel like you can prove the case, I mean, it's your ethical duty as a lawyer, as a bar member of the state, to drop the case. I mean, if you go and try to prove a case that you know isn't lawful or that you're not going to be able to get a conviction off of, you're violating the senator's bar, standards and procedures. So, and I was a SABA member or a SABA, I was on the committee. So, just know there's a lot of at stake, and if we have to just bite the bullet on this one, then that's what we got to do. So I can tell you're very passionate about things, so I don't want you to lose interest in the justice system after this, but I don't know if you have any pull with the MCD, and I have a lot of pull with MCD, so I'm going to talk to my contacts with them, and I'm going to kind of explain my side of things. So, but at the end of the day, they messed up on this, and I know they're not going to like hearing that, but they kind of moved a little too quick on this. Because they could have got all these warrants that you guys, applied for before they even submitted the case. So.
Yes.
Bad for this guy, this Jonathan guy, that he's got such a negative outlook of the DOJ and the justice system. But at the end of the day, we're going to prosecute criminals. So if he's been alleged, if he's a criminal, and he says he's a criminal, or there's been allegations against it, I mean, we have to look into them. So I looked at his MDT profile, and I didn't really see a whole lot. So I don't know what really happened. So
I do not know either.
yeah, he had a warrant on February. So I don't know.
His history to me, whether or not he commit alleged crimes, is not a matter in this case. This case is not about him.
Well, it's about justice for him. He's not. So technically, It is about him, but it's not.
That is what I mean.
Yeah.
Well, thank you again. It is very, very late for me. I will need to go to sleep now. I don't know if there anybody to be reading. Probably not. But it is 2 in the morning, and like the detective didn't even try to get the medical records. She's saying I won't speak to him, doing to I already have a case against him. Then why are you doing this case? That is a problem. Anyway, we will find somebody to be raiding. Maybe. Duplicate tab. I got so many tabs open, constant. This one. Oh my gosh. Let's see. Mr. Walker. Apparently the Skinners are fighting the Lost. I don't know. Raiding though. Let's go. That's not right. Wrong window. I will tell you, I have here we go here. Reading. I have like 100 tabs open, each with different email, different document. I need to go to sleep. Reading. Have the above average night this sunny day. We see what happened tomorrow. Good night.